Stands ready, yes, sir.
Okay.
We're ready, Your Honor. I think both parties would like to start. If Your Honor doesn't have a preference for the motion to suppress, should be a single witness issue, and then whatever the state wants to do next is fine.
Want to be heard?
Well, I would prefer that order as well, but just according to the court, it might not be a single issue. I know the defense isn't put some evidence, and I may put some evidence also depending on what their evidence is. But yes, we would prefer the motion to suppress.
Okay. So, and that is related primarily to fingerprint evidence, is that correct?
No, Your Honor, the motion...
Cell phones?
Yes, Your Honor, cell phones.
Okay. So we've got that issue. We've got the Dahlberg matter on DNA that I understand that there's a motion to continue about that.
Yes, Your Honor.
I'll go ahead and tell you, my intent would be to allow the state to go forward with their evidence, and we can address, and I'll hear more from Mr. Kirby about his motion to continue as well, if he wants to.
Yes.
But not now. Okay. With that, I think I'm just kind of outlining the order
yes, sir.
here. And other than some other matters related to jury selection and the process about that, I was just going to sort of outline some of those things. I don't have, what else, if any, what have I missed?
I think there's an argument on the fingerprint motion that needs to happen today.
Okay.
And then we did file a motion to particularize the witness list. I think that would fit well into the what Your Honor was talking about, logistics discussion.
Okay. So we can begin with the witness that you were wanting to call.
Yes, Your Honor. The defense calls Agent Jamie Hipkiss to the stand.
Is she outside?
Yes, Your Honor.
And Your Honor, and counsel, just for the benefit of you all and Madam Court Reporter, since this is a continuation of the motions, and I suspect when we argue these motions, we'll be referring to exhibits we used last time, like Exhibit 9 and Exhibit 12. The state is just going to start their exhibit numbering at 39 because we left off at 30 last motions hearing. If that's acceptable to the court, I think it'll just make it cleaner when we go to argue.
Sounds fine.
Thank you, Your Honor.
Hey, Judge, if I could just ask, just to make sure that these microphones are off. Last time they were on, and we were.
That's right. Okay. What you're going to need to do is when you need them to be off, because it affects other things, I think there's a button.
Okay.
But otherwise, for right now,
yes,
they need to pick you up.
So. I understand 100%. It is, but my fear is just picking up what's coming through there on the feed. So we would just ask that they be turned off.
Okay.
Agent Hipkiss, would you raise your right hand? Do you solemnly swear that testimony you will give is the truth, the whole truth, and nothing but the truth?
I do.
Please take a seat.
Thank you.
Where are you employed, sir?
I'm employed as a special agent with the Federal Bureau of Investigation. I'm assigned to the office here in Athens.
Agent Hipkiss, does your duties sometimes involve helping in investigating criminal matters in the United States?
Yes.
Are you involved in the criminal investigation of Jose Ibarra?
Yes, I am.
And would you briefly outline just what sort of tasks you've been helping in that matter?
Yeah, so I'm assigned to the Middle Georgia Safe Streets Gang Task Force here in Athens. It's a task force comprised of FBI, GBI, Athens-Clarke County Police Department, as well as the Oconee County Sheriff's Office and the Georgia Department of Corrections. And being a part of that task force, we oftentimes assist in violent crime investigations here in Athens and in Northeast Georgia. So in this particular situation, since this was a crime of violence, it was a murder that occurred here in Athens, we were asked to provide assistance.
And as one of the duties in providing assistance, did you assist with the review of information extracted from cellular devices?
Yes.
And are you familiar with the data that was extracted from phones believed to belong to Mr. Jose Ibarra?
Yes, I am.
I want to start by talking about the way you go about extracting a phone. You use a tool called Cellbrite, is that correct?
That's correct. Our digital forensic examiner in this case did use that tool.
And can you briefly explain what Cellbrite is?
Yes, Celebrate is a forensic tool. In this particular instance, it was Celebrate Premium, which is a more advanced tool. We actually, for the FBI, we only have one in the state of Georgia. And that tool essentially gives the forensic examiner the ability, if the phone is locked, to be able to bypass, or what we call brute force, the phone in order to essentially crack the passcode and be able to access the data on the phone. Once that occurs, the tool then provides an image of the phone, which we then can review as part of the case team.
Are there other software available besides Cellbrite for doing this sort of task?
There are other vendors. Gray Key, made by Magnet, is another one. But Celebrite, I would say, is the most commonly used one. Particularly in this case, the two phones that were examined were Android phones, so Celebrite Premium would be a better tool to use to download those phones.
And you mentioned Cellbrite Premium. Are there different versions of the Cellbrite software?
Yes, there's what they call like a Celebrite UFED 4 PC, which is like the basic version. then obviously Celebrite Premium being the more advanced.
And what is the difference between the information that Celebrite Premium can extract versus Celebrite UFED for PC?
Since it's a premium version, of course, it has the ability to, if you have a password protected phone, it has a greater success rate of getting into the phone than for the basic version of Celebrite, for instance. Additionally, because of the capabilities of more advanced technology, it has the ability to extract more data.
Okay. So help us a little bit with terminology. When you extract a phone, what you get, you call your forensic image, is that right?
Yes, it's an image, or it's basically like a replica, as best as the tool can do, a replica of what's on the device.
And this image can have different kinds of data within it, depending on what kind of image you're looking for, right?
Yes.
Can you please explain? I understand there are 3 kinds of forensic images. Would you please explain those to us if you can?
I'm not sure what you're referencing.
Can you explain the difference between logical forensic images, file system forensic images, and physical forensic images?
Yes. As a case investor, I did not do the forensic examination on these particular phones, but I do have basic knowledge from a case investigator standpoint. So like a logical would be essentially like the least amount of data that you would be able to get from the phone. Full file system, which was done in this case, would be more data that you would be able to get from the phone. Okay. It's basically different levels of data that could be extracted from the phone.
And am I correct in saying that in this case the data that was extracted was a physical image, so all the information that could be obtained?
I believe it's referred to as like a full file system or file system extraction.
Okay. But you would agree with me that whatever the highest level of forensic extraction possible, that was the level used on these phones?
My understanding, and again, I did not do the download of the phone, so I'm relying on what I've been told by other members of our team, is that it was only capable of doing that particular type of download.
Okay. So when you use Celebrite Premium to generate this physical extraction, is there a way to limit what data Celebrite Premium will extract?
No, in a full file system, you're going to essentially image the entire phone. It's going to pull all the data that the tool can pull. So no. Okay, so just to be clear, if you were wanting to limit the data by a date range, for example, Celebrite Premium is not capable of doing that limitation. Is that fair to say? Yes, on the first step. So basically there's a 2-step process. The first step being the imaging of the phone by the tool, which is going to capture everything, right? From there, then we're going to put it into a reader, which allows the data to be parsed out, and then we as the investigator, I'll get that data, and I will filter it out at that point to the date range that's listed in the search warrant. So I want to talk about now turning your attention to the particular extractions that were done on phones 1B7 and 1B8. We talked about this the last hearing that you were not present at, but just as a recap, is it fair to say 1B7 and 1B8 are the nicknames assigned to the phones believed to belong to Jose Ibarra? Yes, that's correct. Those numbers are used by the FBI. It's a common protocol that we use to label our evidence. So yes, 1B7 and 1B8 are phones that we've attributed to Jose. Okay. Your Honor, permission to approach the witness?
No.
So Agent Hipkiss, I just handed you a document. Can you take a moment to verify that this is a Celebrite report for phone 1B7?
Yes, let me just review it for 1 second, please. Yes, it is. Okay. And you were given a copy of this report in advance of today's hearing, is that right? That's correct. And this is a report that contains data extracted from phone 1B7 that predates January 1st of 2022? That's correct. Your Honor, at this time, defense would like to move Defense Exhibit 3 into evidence.
Any objection?
May I have a moment to question the witness, Your Honor?
Yes.
Special Agent Hipkiss, did you create this report?
No, I did not.
And do you know who created this report?
I do not. It was emailed to me this last week by the defense counsel, but I'm not sure who created the report.
Do you know if the person who created this report has any training in cellular reader and embed reader?
No, I do not.
Of the information that is in Defense Exhibit 3, when it was sent to you earlier this week, is that the first time you had seen some of the information that was extracted from the phone?
Yes, it is, because I was reviewing with the date range that was in the scope of the warrant. So this is the first time that I've seen this data, yes.
That's all I have, Your Honor. I won't object to its admission, and we'll just start new later.
Resubmitted. Defendant's through.
And just to follow up on those questions, Agent, you were able to verify that everything in this report was extracted from phone 1B7?
Yes, per your request, when it was emailed to me, I did look at the Celebrite report, which I can verify is a Celebrite report, and I looked at the data, and it appears to be consistent with the original Celebrite reader report that was created by our digital forensic examiner. Okay. So let's talk about how we get to limited reports like this from a large cell phone extraction. So when Celebrite extracts a physical image from a phone, that's a lot of data, right? Yes. And in this case, phone 1B7 had over 35 gigabytes of data, right? I believe so, yes.
Did you ever, just for curiosity's sake, did you ever try to turn that into a PDF file with all the data on it?
No,
Would you?
I did in the sense of when I reviewed the phone during the time frame listed in the warrant, I found evidence that I felt was pertinent. I tagged that as pertinent evidence that we were seizing, and I created a PDF report at that time, which I turned over to the prosecutor, which was ultimately turned over to you.
Would you be surprised to hear that if you made a PDF out of everything in the report would be over 87,000 pages?
I wouldn't be surprised. I mean, I've reviewed a lot of phones in my career, so I wouldn't be surprised by that.
So this report is just a sampling of certain kinds of data within this 87,000 page report that could be generated?
Yes.
Okay. And phone 1B8, there was a little bit less data. Would you agree with me that we had close to 13 gigabytes of data?
Yes, that sounds about right.
So it'd still be several thousand images or pages within a PDF format?
Yes.
Okay. So when you get this data, you have a tool called the Celebrate Reader, which kind of helps you review and organize the data. Is that fair to say?
Yes.
And you, as a part of your discovery application in this case, or the state, you turned over that reader to the defense counsel. Is that fair to say?
Yes, our standard procedure in regards to the discovery process would be to turn over everything that was initially captured in that first phase that I explained. And that would give the defense team the opportunity to conduct their own independent review, which is what I did in this case.
Sure. And the reader is what allows us to filter evidence by parameters like dates. The reader you can plug dates into the reader and it sorts the data into the limited category that meets that criteria.
Yes, but I will say, based on my training experience and examining a lot of phones, the tool doesn't always capture the date and time. There are instances where there is no date and time. In that case, our standard procedure would be to further review that data to determine if it is within the scope of the warrant.
And in your review of phones 1B7 and 1B8, was there data like you just described that didn't have a date associated with it?
Yes.
And did you review that data that didn't have a date associated with it?
Yes, I did.
And were some of the images that didn't have a date associated with them later used in search warrant affidavits for further inspection of the phone?
Yes, and if I could just give an example of that whole process. So how I normally explain that would be a similar situation. If you're going to a residence to conduct a search warrant, say for a firearm, right? And we went inside the residence, and let's just say we went into the suspect's bedroom and we were searching anywhere a firearm could be hidden in the bedroom. If, for example, we went and there was a dresser in there and I pulled out the dresser drawer and there was clothing in there, the next logical step would be to move the clothing to see if the firearm's in there. In this scenario, I equate that to the same because it does not capture a date and time in the Celebrate report. I feel I have the obligation to review it further to determine whether it is or isn't in the scope of the warrant. If it is, then of course, we would seize it. In this case, once I started to review it and I could not determine when it was captured, then we went back to this court, obtained another search warrant requesting to seize that particular information.
Understood. Your Honor, may I approach the witness of the defense exhibit 4?
Yes.
Please go over that report, let me know when you've had a chance to do so.
Yes, ma'am. Yes.
Is this a report extracted from phone 1B8 to the other phone that we believe to belong to Mr. Ibarra?
Yes, it is.
And is this also a summary of the data on that phone that was extracted that predates January 1st of 2022?
Yes.
At this time, I move to enter Exhibit 4 into evidence.
A few questions. Same question. Special Agent Hitkiss, did you create the Celebrate report?
No, I did not.
Do you know who created Defense Exhibit 4?
No, I do not.
Do you know if the person who created Defense Exhibit 4 has any specialized training in Celebrate and Fed Reader?
No, I do not.
And the data, I think the word was, does it contain a summary of the data? Does it contain a summary of the data, or is it the data?
Based on my review, per the defense's request, I tried to replicate it. I believe it's all the data that was captured between January 1st, 2019 and December 31st, 2021.
So it's not a summary, it's all the data, correct?
Yes.
And when you reviewed 1B8, did you even see or capture this data and put it in your seizure report?
No, I did not.
Why did you not do that?
Because it wasn't in the scope of the warrant. I only seized, and I wrote a report following my review listing what we did as part of the review, and then I created a separate PDF document and also tagged in the Celebrate Reader the pertinent evidence that I thought was in the scope of the warrant, which I thought was the evidence that we actually seized.
So Defense Exhibit 4, you believe, was not within the scope of the warrant, correct?
Yes.
And you did not see Defense Exhibit 4 or that data until it was given to you by the defense attorney, is that correct?
No, and it was turned over to the defense as part of our normal discovery process.
Yeah, the whole extraction was turned over to
Right,
you.
right.
My question is about this specific exhibit.
Yeah, no, I had not seen it until the defense had emailed it to me.
That's all I have for the questions at this time, Your Honor.
Is there an objection to
Not-
admissibility at this time?
Not for the admissibility, no.
Or submitted?
And Agent, just like I asked on Exhibit 3, you were able to confirm that the data in Exhibit 4 was part of the extraction for phone 1B8.
Yes, based on my review, it appears to be the same data from the original report for 1B8.
Okay. Your Honor, permission to approach the witness with defense exhibit 1.
You may.
Agent Hipkiss, a few moments ago we talked about a Cellbrite reader, and I just wanted you to briefly explain to us what does it look like when you're looking at the reader that's kind of accessing the data of an extraction?
It will have like a line-by-line file data, I would say. Like, if the date and time is captured, it will list that. It will also list the file path, which will oftentimes tell us like what application was utilized to capture that particular data, whatever it may be, a photograph or a video or WhatsApp messages. There's going to be additional data in there to basically tell us what the source is.
Okay. And directing your attention to Exhibit 1, is this fair to say it looks like a screenshot of what a user of this reader report would see when they're looking at the data?
Yes.
And is this image displayed on Exhibit 1 and the data associated with it, are they part of the extraction from cell phone 1B7?
Yes.
At this time, defense moves to admit Exhibit 1 into evidence.
No objection.
Defense exhibit 1 is admitted.
Okay. And Agent, the only question I want to ask you about this image, well, two questions. One, we heard last week that this image was that of a GBI agent. Does that appear to be accurate from your review of the image?
Yes.
And can you tell us what time this image was captured on the phone 1B7?
Yes, it was captured on February 23rd, 2024 at 9:20 and 25 seconds p.m., which appears to be in Eastern time, so local time. And it was captured using the Third Eye Intruder application.
And Third Eye Intruder application, what is that?
Based on my research, it's the first time I've encountered an investigation. It's essentially an application that one can install on their phone that if anybody manipulates their phone or swipes on the screen or inputs an improper passcode, that it would capture the photo.
And isn't it true that Third Eye Intruder takes a photo when someone's trying to enter the incorrect password?
Objection.
Well,
being-
I mean, he can answer yes or no to that question, but I can rephrase.
I'll sustain the objection.
I would say I would answer that.
Let him answer. Let her ask him a question.
Sorry, Agent. Can you just explain when, to your knowledge, Third Eye Intruder would take a photo?
It could take a photo when the passcode is, or the pattern lock, depending upon how the phone is set up, is entered. But I know from training experience and best practices of collecting a phone that the first thing that you want to do to preserve data on the phone would be to put it in airplane mode, which would require you typically on an Android phone to either swipe down or swipe up, which I would imagine, I didn't have personal involvement in this, but I would imagine
I'm not asking to speculate, but to your knowledge, the application takes pictures, as you said, when someone is manipulating the phone. Is that fair to say?
Yes, when somebody has done something on the screen, it wouldn't, based on my research on it, it wouldn't necessarily be, it could be from other things other than trying to put it in an improper code.
Okay.
It could be from swiping the screen.
And did you test that with Third Eye Intruder?
I did not personally.
Okay, so the last time we were in court, Agent, we learned that the phones, when they were seized, were stored in a Faraday bag. Could you briefly explain for us what a Faraday bag is?
Yes, Faraday bag is a forensic tool that's used to try to preserve the phone in the sense that it eliminates any cellular signal from reaching the phone. And so some law enforcement, there's varying models, some are more expensive than others, have access to these. And part of the best practice of collecting a cell phone would, one, be to, like I mentioned, put it in airplane mode, disable Bluetooth or Wi-Fi, and then put it into a Faraday bag. Okay. But we've discovered over time that the Faraday bag is not the 100% solution. That's why you take those other steps, such as putting it in airplane mode to try to preserve the phone. And
would the phone being put in airplane mode be something that was logged on the device, the device event?
Yes, typically, if the tool would pull that data. But in this case, my understanding, and again, I was not involved in this, but my understanding was they were not able to put the phone in airplane mode unless the pattern was entered into the phone to unlock the phone.
Okay, I'm going to, Your Honor, permission to approach witness with defense exhibit 2.
Right.
And Agent, you can go to review this report and let me know when you've done so.
Yes.
Agent, is this a report generated from data extracted from phone 1B7?
Yes, it is.
And what particular data is this report focused on?
It's focused on the device events.
And I know I used that term earlier. Would you please explain what we meant by device events?
Yes, that's as you stated earlier, the Cellbrite collects various forms of data with the ability to filter by specific things such as device events or pictures or photos. In this case, you filtered between, or whoever created this report filtered between February 23rd, 2024 and February 27th, 2024 for just the device events, meaning what was the device doing during this time period.
Okay. At this time, Your Honor, defense would like to enter defense exhibit 2 in evidence.
Briefly, Your Honor. Special Agent Hipkiss, did you create Defense Exhibit 2?
No, I did not.
Do you know who created Defense Exhibit 2?
No, I do not.
And do you know if that person had any training in Celebrate You Fed Reader in creating Defense Exhibit 2?
No.
All right, that's all I have for now, Your Honor. No objection.
To submitted.
So, Agent, I just want to highlight some of the device events in this report. We don't need to go through all of them, but before I do that, each device event, does it have a date associated with it?
I believe so, yes.
And does it also have a time associated with it?
Yes.
And when we see a time on this exhibit, it says UTC. Can you explain what that means?
Yes, that's universal time. So in comparison to Eastern Standard Time, at this on February 22nd and 23rd of 2024, UTC time is 5 hours ahead of local time.
Okay. And so when we see timestamps on this report, is it fair to say we have to subtract 5 hours to figure out what it would have been in Eastern Central Time?
Yes.
Okay. Eastern Standard, excuse me.
Yes, ma'am.
Okay, so let's start on row 23, which is on page 3 of the report. This is an occasion when the phone was turned on. Is that right?
I don't believe so.
This is an occasion when the display of the phone was turned on.
I'm sorry, you said row 23?
Yes.
Yeah, according to the report, yes.
Okay, and what time is associated with that display being turned on?
6:30 and 2 seconds p.m. UTC time, which would translate to 1:30 p.m. local time on February 23rd, 2024.
And according to this report, when was the display turned off next?
It looks like...
I'm going to object to the form of the question. She can read the data and have him read the data, but when she said the display was turned off, she is assuming that the display was turned off. She needs to read the data as it appeared on the report.
Judge, I asked when the report said the display was turned off, so the agent can direct wherever in the document that would be.
If that is your question, I will allow it.
Your agent, when does this report say that the phone screen was then, or the display was then turned off?
At
I
6:30.
think her objection is related to the phrase when, that indicates when the display was turned off.
Yes, sir.
I haven't seen it, so I don't know what it says. I think he's limited to testifying what the report says, not what could have caused that entry in the report.
Yes, Your Honor. I thought I asked that way, but I'm happy to rephrase. Agent, what does the report say about when the phone screen was turned off?
It says it was turned off at 6:36 and 9 seconds p.m. at UTC, which is 1:30:36 local time. I mean, based on my review, I can see that the source is Samsung Rubin data, and I am familiar with that. I don't believe, the way you're phrasing it, it sounds like you're phrasing it like somebody's actually turning the phone on and off. Like, that's just the phone doing that, I believe. I don't believe it's somebody actually turning the screen on and turning the screen off.
Well, I didn't actually ask you about who was doing what, but let's talk about Samsung Rubin. What is that?
Samsung Rubin data is data that's specific to Android phones. And so Samsung Rubin data is essentially, it's the phone talking to itself. It's the phone constantly monitoring the state. And it's something that you opt in as the user of the phone from the time that you get the phone. And the purpose of that is for many reasons. One, it'll monitor your location. So if those of you that have smartphones notice when you get in your car in the morning and it says, hey, you got a 51-minute commute to work, that's the phone basically monitoring you in the background. It also is for ad targeting because it monitors where you go and strategically sends ads to your phone. And so it's basically the phone checking on itself in the current state that it's in.
Sure. And so the phone is recording what's happening to it, but you're telling me the app is just recording what's happening to the phone. It doesn't tell how the phone is being manipulated. It just says what's happening.
Yeah, for example, I mean, if you just want to go to line 17 and it says Wi-Fi state off, that's just saying that the state of the phone, the Wi-Fi is disabled. It's not saying like somebody came over at that very moment and turned the Wi-Fi off. It's just registering the state of the phone.
Understood. But back to what we were talking about, the state of the phone was registered to be on at 6:30 UTC, is that right? Row 23?
Yes.
And then you had mentioned that it appeared to be turned off, or the display was registered as off on 6:36 UTC.
Yes.
Okay, so let's drop down again to row 25. What data does that information display?
It's 6:39 UTC or 1:39 local. It shows that the display is on again.
And then when does the report say the display is turned off?
Approximately 30 seconds later, so at 6:39 and 44 seconds UTC or 1:39 p.m. local.
Okay, row 27, what data does that row display?
It again says the display is on, and that's at 6:40 UTC or 1:40 p.m. local.
And when does the report indicate that display is turned off?
At 6:41 p.m. and 9 seconds UTC, 1:41 local.
All right, I'm going to skip a bunch of data that I don't think is very relevant for today, and I'm going to direct you to row 57 of the report.
Yes, ma'am.
Let me know when you get there.
I'm there.
What data does row 57 indicate according to the report?
It states that on February 23rd, 2024, at 8:45 and 45 seconds p.m. UTC or 3:45 p.m. local, the display is on.
And when, according to the report, does the display turn off?
It would have been almost a minute later, so 8:46 and 20 seconds p.m. UTC.
Okay. And then row 59, what does that data display?
Again, it displays on February 23rd, 2024 at 8:50 UTC p.m. And that's 3:50 local.
And what occurs to the phone at that time?
The display is on.
Okay. When is that display turned off?
At 8:51 p.m. UTC or 3:51 p.m. local.
Okay. Directing you to row 63, what data does that row display?
63 on February 23rd, 2024 at 8:52 p.m. UTC or 3:52 p.m. local. The display is on.
Okay. And when does the display turn off, according to this report?
At 8:52 p.m. UTC or 3:52 local.
And then row 65?
Row 65, again, February 23rd, 9:35 p.m. UTC or 4:35 local time. It's on. The display is on.
And in an effort to shortcut the court's time here, Agent, is it fair to say throughout the document there are a few more instances where the display is registered as on?
Yes.
And are all those display on data followed by a display off data?
Yes, what I think would be normal.
All right, so I'm not going to make you go through all of the other ones on this document, but would you agree with me that over the next 2 days captured by the report that there are multiple of these?
Yeah, which I would think would be normal if the phone received a notification, the screen would turn on.
Well, in just a moment, Agent, isn't it supposed to be in airplane mode at this time?
Well, it wasn't in airplane mode because it couldn't be put into airplane mode, which means that upon further review, outside of what you have in your report, it was receiving incoming WhatsApp messages, which means that the Faraday bag essentially failed. So it did have some sort of signal.
So the Faraday bag failed?
That's what it appears to me. It appears it was getting some sort of signal because we weren't, or I say we as law enforcement, weren't able to take all the necessary steps to preserve the data that being put in airplane mode. It wasn't possible. We weren't able to disable Bluetooth or Wi-Fi. So it was only put in a Faraday bag. So we're automatically right off the bat eliminating one step of best practices of collecting that device by the virtue of the state of the phone.
Sure. And then just, is it also possible that the reason the phone is receiving data at certain times is because it's not in a Faraday bag?
When I received the device, it was in a Faraday bag. So I don't. What happened outside there? I wasn't with the phone until I received it on February 27th at about 10:15 in the morning.
My question is another explanation for why the phone was receiving data is another possible explanation that it was not in a Faraday bag?
I mean, it could not be in a Faraday bag. It could be in a Faraday bag.
So it's
it could be in a Faraday bag and receive data.
It was either in a faulty Faraday bag or it was not in a Faraday bag. Is that correct?
I don't want to say faulty. I mean, there's a lot. I mean, you literally would have to get the Faraday bag and use equipment to determine if it was 100. If it was working the way it was supposed to work. But what I want to emphasize is we were already eliminating one step of the process to preserve it and prevent a signal going in there because they could not put it in airplane mode.
Okay.
So that was not possible. So we're putting it in a Faraday bag, but it's not in airplane mode. So, and when you put it in a Faraday bag, the phone, it's because it always wants to have the best signal, right? That's why we get phones. We want a phone that we can pick up and dial and it connects to whoever we're calling to. So when a phone is in Faraday bag, actually how that phone reacts is it works even harder to try to find a signal. So I wouldn't consider it unusual at all for there to be incoming data coming in when they couldn't put it in airplane mode.
But you did say earlier you thought that the Faraday bag had a flaw or a fault to it.
That could be one reason, yes. But without taking that particular Faraday bag and using other equipment and testing it, I can't say for certain.
Sure. Thank you, Agent. I have no further questions.
Thank you.
Special Agent Hipkiss, when you first picked up 1B7 and 1B8, where were they physically located?
At the University of Georgia Police Department.
Were they both in Faraday bags?
Yes, they were, and they were in their evidence storage room when I received them.
And what day did you pick them up?
On February 27th at approximately, February 27th, 2024, approximately 10:15 in the morning.
Did you or did the FBI or was there a warrant obtained for 1B7 and 1B8?
At the time that I collected the devices, yes, there was. We obtained a warrant from this court at approximately 9:35 in the morning.
On 27th day of February, 2024?
Yes, ma'am.
And after a warrant was signed, was that signed by Judge Stevens?
Yes, it was.
Okay, and he signed a warrant for 1B7, 1B8, and other devices as well, correct?
Yes, ma'am.
And after that warrant was signed by Judge Stevens, is that when the phone and the FBI attempted to extract data from the phone?
Yes.
When you picked up 1B7, what, if anything, did you do to 1B7?
I did. So it's important that the phone remained on as far as data preservation. So when I received the phone, I brought it back to our office here in Athens, and I opened the Faraday bag and I pressed the button on the side to ensure that it had remained powered on, which it did.
It had remained powered on?
Yes, ma'am.
And was the phone 1B7 locked or unlocked?
I couldn't tell because all I did essentially was hit the side button and it just lit the screen up. So I couldn't tell, but based on discussions with other law enforcement that were involved in the extraction process, I know that particular device was locked by a pattern lock.
Okay, and what is a pattern lock?
Pattern lock is common to Android phones, and so rather than type in a PIN of like a number, a numeric code, pattern lock will typically, like in this case, I believe it was a Z, so the user will type in some sort of pattern to unlock the device.
Okay, and you only knew it was a Z after the fact, correct?
Yes.
Okay, and that phone had to be what you call brute force, and I'm specifically talking about 1B7, had to be brute force opened by a tool called Cellubrite Premium, is that correct?
Yes, ma'am.
And it was Special Agent Candace Hunter with the FBI that was able to unlock that phone, is that correct?
Yes, ma'am.
And the date that Special Agent Candace Hunter unlocked that phone was what day?
February 27th, after the search warrant was obtained.
So the same day, but after Judge Stevens signed the search warrant?
Yes.
Okay. And you can actually see that based on defense exhibits that were provided, correct? For example, you have defense 2 in front of you?
Yes.
So that we can see when whoever made these exhibits made them, it states when the date and time of the extraction of the device. Is that right?
Yes, it does.
And I just have defense exhibit 2 up, but it says 2/27/2024, correct?
Yes.
Okay. And why would the phone have to be brute forced?
Because we did not know the pattern lock code to access the device. So essentially the forensic tool had to do the work for us. So in essence, we plug it into this forensic tool and it tries all sorts of various passcodes in order to crack into the device. And the tool has the capability of, like, if you were to manually try to do that, for example, a lot of phones, if you enter the passcode incorrectly like 10 times or so, it'll lock you out of the phone. But in the case of this forensic tool, it allows the tool to keep trying variations of passcode without it locking the device.
So even if you or anyone else wanted to search the phone prior to Judge Stevens signing that search warrant, you would be unable to because you did not have the passcode for the phone. Is that correct?
Yes.
You could not open that phone. Is that correct?
Yes.
And no one could open that phone unless they had the passcode to it. Is that correct?
Yes.
And the only time that 1B7 was ever opened was when Candace Hunter was able to brute force the password on the 27th day of February 2024. Is that correct?
Yes.
Defense Exhibit 2 is Rubin data, correct?
Yes.
And what is Rubin data in general terms?
Like, it's just a personalization data is what was commonly referred to. It's basically the phone tracking your movements and your activities on your phone to make the phone a better experience for you, essentially.
And is the phone talking to itself? Is that correct?
Yes.
And does Defense Exhibit 2 mean that you or anyone from the GBI or anyone in law enforcement was physically turning on and off this phone 1B7?
No.
Does it mean that?
No.
You obtained, in fact, 2 search warrants for 1B7. Is that correct?
Yes.
The first one you told us was on the 27th day of February. When was the second one?
On April 24th, 2024, we obtained a second search warrant for 1B7 and then also a second search warrant for 1B8.
And after obtaining a second search warrant for both phones, and just briefly, without being too specific, why did you obtain a second search warrant?
We believe we found evidence of additional crimes. So because of that, that was one of the reasons. And then again, upon my review of the data that didn't have any time or date stamp, I had to review that further to try to determine whether that fit into the scope of the warrant or not.
And so did you seek permission from Judge Stevens to, in fact, to do that?
Yes, when I went back with the second warrant, that was specific to 1B8. We went back to Judge Stevens and told him that there was data on there that we felt was relevant to the crimes under investigation. There was no date and time associated with this particular data, but we requested his permission to seize that data pursuant to that second search warrant.
Okay. And after you obtained both search warrants, did you then do a review and seizure report of the data from both 1B7 and 1B8?
Yes, on or about June 3rd, 2024 is when I created my review report and I attached, we call it 1A attachment, it's essentially attached to the report. I created a PDF for 1B7 of all the data that we seized that we felt was pertinent to the investigation within the scope of the warrant based on our review, and I did the same thing for 1B8.
May I approach the witness, Your Honor?
Yes.
Amendment what's been marked for identification purposes. Is State's Exhibit 31, do you recognize State's 31?
Yes, I do.
What is it?
This is a thumb drive containing the reports I just referenced. So the review report for 1B7 along with the attachments, and then also the review report for 1B8 along with the attachments. And I know this because I got my initials on it. Previously reviewed.
I'm sorry, go ahead.
I previously reviewed it, so yes.
And in State's Exhibit 31, the items of evidence that you seized out of 1B7 and 1B8.
Yes.
So you moved to State's Exhibit 31.
I would ask that, no objection, I would just ask that information not be published this time due to the news in the room.
Your Honor, we will seek to have the same order that we had last hearing to cover State's Exhibit 31 as well.
And no objection.
And I just ask that we take a break, the court doing a camera inspection of it, and we'll present an order to the court for your consideration.
Very well. 31 submitted.
When you created your review and seizure reports for 1B7 and 1B8, did you do so within the scope of the warrants that Judge Stevens signed?
Yes.
And did you limit your search to both 1B7 and 1B8 within date parameters that Judge Stevens set out in the warrant?
Yes.
How did you do so? Tell us.
So when I received the Celebrate reader file, I was able to go in and I was able to filter the data by the particular dates in the warrant, which on the original warrant, the date range was January 1st, 2022 to February 27th, 2024 when the warrant was authorized.
And were there two different ranges, one for 1B7 and 1B8?
The original warrant was the same. When we obtained the second warrant, we narrowed the scope down as far as the date range even further. So for 1B7, we narrowed it down on the second warrant to, I believe, September 1st, 2023 to the date and time the warrant was authorized. And then on 1B8, we narrowed it down to September 2023, I believe. I'm not 100%. I'd have to look at the warrant.
That's right.
But it was narrowed down to the condensed date range.
And you used those date ranges to narrow your search of the phone when you were looking through the phone and complying with the warrant. Is that correct?
Yes.
So let's talk about data that has no date range. First of all, how can data in a cell phone have no date range?
A lot of times when we see that, it's been deleted data that's been recovered by the forensic tool. It doesn't have a date or timestamp. Additionally, when we have to use a technique that I described for 1B7 of brute forcing the phone, a lot of times it won't capture a date or time stamp for data when we do that process as well.
And so why is it that you look at data that doesn't have a date range when you're trying to stay within the date range that the judge put in the warrant?
Because it could be in the date range. So a lot of times what we see, I mean, essentially, like if people deleted stuff from their phone, then that would basically get them a free pass. I mean, if it was in the date range and they deleted it, if we didn't review that further to determine when it occurred, then people could just delete stuff from their phone and we would never be able to use that evidence. But in this particular case and in other cases, when we look at it further, I'll just use the example of like a text message communication that had been deleted. I can look at that data further and I can see that it fits in with other communications that occurred within the date range of the warrant. So I feel like I have to do a further review in order to determine the source of that.
And is that what you did in this particular review of both phones?
Yes, and then of course, if for some reason I was able to determine that the data was captured outside of the scope of the search warrant, then we wouldn't seize that data.
But you have to look at data that has no date on it in order to determine whether it's within the scope of the warrant or outside the scope of the warrant. Is that correct?
Yes.
And in searching 1B7 and 1B8, did you stay within the confines of the scopes of those warrants?
Yes.
Now, why is it, Special Agent Hipkiss, that when Cellubrite Premium had to brute force this phone, why couldn't you just tell Cellubrite Premium, well, just give us these dates in the phone? Why can't you do that? Why do you have to extract the entire phone and then subsequently search it?
That's the way the tool is set up. I don't know the reasoning behind that. I mean, obviously, like an engineer who designed the tool would have to answer that. But we can only review what we receive, and in a lot of times the tool doesn't have the capability of extracting the date and time or determining when that particular event occurred.
And when the phone is physically extracted and the phone is completely downloaded, you said you give a copy of that to the defense so that they can have the entire phone should they want to do things with it, like create defense exhibits 1 through 4, for example, correct?
Yes, we actually state that in the warrant, in essence. On the last page of the warrant, it states that we will provide a complete copy of the data that was imaged to the government for independent review, which would then obviously be turned over to the defense.
Right. And I know exactly what you're talking about. Hold on a second. 2 things. May I approach the witness, Your Honor?
Yes.
I'm going to hand you what's already been admitted to State Exhibit 9 from last hearing. And on page 13 of State Exhibit 9, I want you to read silently to yourself the highlighted part. I'm going to ask you a question. Have you read it?
Yes.
Does State's Exhibit 9 and did Judge Stevens authorize you to do exactly what was done in this case, which is download the entire phone?
Yes.
All right, and can you read to us the pertinent language that you believe authorized you to download the entire phone?
Yes, it states nature of examination based on the foregoing and consistent with Rule 41 E2B, which is a federal rule, which I'm familiar with, which essentially states that we have the authority to execute the warrant outside the hours of 6 and 10 since it's a device in our possession. Additionally, it gives us the authority to extract the contents of the phone and review it at a later date. Following that code section, it goes on to state the warrant I'm applying for would permit the examination of the device consistent with the warrant. The examination may require authorities to employ techniques, including but not limited to computer-aided scans of the entire medium, that might expose many parts of the device to human inspection to determine whether it is evidence described by the warrant.
And go to page 13 of the warrant. States Exhibit 9 again for the record.
I'm sorry, what page?
I'm sorry, may I have your tenure?
Yes.
Yeah, the page numbers. You're on 13, 17, which is actually the warrant itself. You were telling us that the warrant authorized you to make entire copies of the phone. Page 17, you see the highlighted portions? Reach
Yes.
here. Is that what you were referring to?
Yes.
Could you read that to the court, please?
The review of this electronic data may be conducted by any government personnel assisting in the investigation, who may include, in addition to law enforcement officers and agents, attorneys for the government, attorney support staff, and technical experts. Pursuant to this warrant, the FBI may deliver a complete copy of the seized or copied electronic data to the custody and control of attorneys for the government and their support staff for their independent review.
And so did you comply with all three of Judge Stevens' warrants in searching these two phones?
Yes.
I want to ask you finally about Defense Exhibit 1, the Third Eye Capture app. First of all, it's like an anti-theft app, you told us, right?
Yes.
Okay, so does that mean that Defense Exhibit 1, that agent, for example, searched 1B7, that phone?
No, I don't believe it does.
And why not?
I believe that he was probably trying to put it in airplane mode, and that's what generated the phone to take the selfie image.
Your Honor, I'm going to object lack of personal knowledge. That's what his already testified he was not there at the time, so having to speculate about what was happening is inappropriate.
Sustain the objection.
I'll call the witness next. He's right outside. And I think that's all I have for this witness. Thank you, Your Honor.
Anything else, Ms. Riley?
Yes, Agent Hipkins, I'm working with my own copy of the search warrant, so forgive me if it has numbering system different than yours.
Yes.
But the language you were reading from was from the affidavit attached to the search warrant, right?
Some of the language I read, yes, the nature of the examination, that was part of the application affidavit that was presented to the judge. The last language that I read was one of the last paragraphs on the actual search warrant.
Did anywhere in so in the order, it doesn't actually talk about the full extraction that you read from the affidavit, is that fair to say?
No, it's in the application and affidavit.
Okay. The actual order does indicate that the data is to be limited to a certain date range, right?
Yeah, it's based on the evidence we could see is limited to a certain date range. That's correct.
Okay. Did anywhere in the affidavit for States Exhibit 9 or subsequent to States Exhibit 9, did anywhere in the affidavit spell out for the judge that we don't actually have the capacity to limit our extraction of the phone, the date range we proposed?
I don't believe that. I don't know. Is this States Exhibit 9 that the prosecution is handing me? Or?
Is that the 10? I'll come back.
Yeah, I prefer to look at what you're referring to.
Are you looking at, which one are you looking at?
I was looking at Exhibit 9, States Exhibit 9.
I'm sorry if you don't mind repeating the question too.
Sure. Are you aware of anywhere in States Exhibit 9 where the government tells the judge that there is no way to limit the extraction to the date range authorized by the warrant?
No, but I believe we tell, based on my interpretation of the warrant.
Well, I'm not asking for interpretation. You just, in this affidavit, you never tell the court that you cannot limit your search of the phone as the date range would apply.
But no, based on my involvement, I'm relying on the warrant, and so I have to have my own interpretation of the warrant in order to do my part of the investigation. So upon my review, it essentially states that we could search all 10 devices, and that then we could seize what's related to the crimes in that date range. So the way that I interpret it is that the judge has given us the authority to search the entirety of all 10 devices, but we only have the authority to seize what is within the scope of the warrant within that date range as it relates to the crimes under investigation.
This is a warrant for search and seizure, yes?
Yes.
So this warrant limits your ability to search as well as seize, yes?
Objection, leading.
Sustained.
Agent Hipkiss, I am just asking for an answer to my question. Anywhere in this affidavit, do you say to the judge, we cannot extract the data within the date range you gave us?
I don't believe so, but
Okay, no
I mean, I would have to review the warrant in its entirety to be certain.
Special Agent Hipkins, how can you, sorry, let me go back to that. Oh, thank you. How can you seize items within the scope of the warrant if you can't search through the phone?
Yeah, to elaborate on that, you know, if we didn't have we needed the forensic tool, obviously, to extract the data because it was password protected. But like, if this phone, like 1B8, for example, wasn't password protected, like, we would have to. The alternative is hand searching the phone, which means I would have to search everything. There's no way for me to figure out the date range without searching through the whole phone. It's not parsed out like it is in the Celebrite reader. So I don't understand. It doesn't seem possible to do what she's stating.
Okay, that's all I have.
Any other questions with that?
No, Your Honor.
Will you be excused?
Yes, Your Honor.
Objection?
No, Your Honor.
You're excused.
Thanks, sir.
Anything else on this issue?
Not from my side, Your Honor.
Ms. Ross?
State calls Special Agent Cameron Karate. Raise your right hand, please, sir. Do you swear affirm the testimony you will give today in the matter of the state of Georgia versus Jose Ibarra will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please take a seat. Where do you work?
For the Georgia Bureau of Investigation.
What do you do for them?
I'm assigned to the Appalachian Regional Drug Enforcement Office, primarily tasked with investigating narcotics.
Are you a post-certified law enforcement officer?
I am.
Were you assisting the Georgia Bureau of Investigation, the Athens-Clarke County Police Department, and the University of Georgia Police Department in the investigation into the murder of Laken Riley in February of 2024?
Yes.
And pursuant to your assistance, did you find yourself at the defendant's apartment on February 23rd of 2024?
Yes.
Did you assist agents there in collecting cell phones?
Yes, I did.
I want to ask you specifically about two cell phones that were identified to you by a resident of the apartment. Her name was Rose Belly. Do you remember her?
Yes, ma'am.
And did she identify two phones to you?
Yes.
And did she identify two phones that she said belonged to Jose Ibarra?
Correct.
Did you seize those two phones?
Yes.
I want to talk to you about your seizure of both of those phones. First of all, were they Samsungs or were they Apples or what were they?
They were Android devices, yes. So they would be Samsungs.
When you seized those phones, did you attempt to keep them powered on and put them in airplane mode?
Yes, I did.
Why do you do that?
We do that to preserve potential evidence that may be stored within those particular devices or any device in reference to the crime being investigated.
Could you, why does putting them in airplane mode do that?
Because devices can be remotely wiped by any individual that has access to do that to that particular device.
So putting in the airplane mode can prevent that?
Yes.
One of the particular phones was passcode protected. Do you remember that?
Yes.
And did you attempt to put that passcode protected phone into airplane mode?
Yes.
How did you do so?
For Android devices, typically, I believe you have to swipe up from the bottom of the device in order to activate the lock feature, which in this case, typically Android phones have a pattern lock as their password. So I would have swiped up to activate the pattern lock and then attempt to put the pattern lock that was provided to unlock that phone.
And who provided you a pattern lock?
That would be Ross Belly, Flores Bayo.
And the pattern lock that she gave you, did it work?
It did not.
Did it unlock the phone?
No, it did not.
Were you able to unlock that phone?
No, I was not.
Were you able to put that phone in airplane mode?
No,
Did you search that phone?
I did not.
And when you left there, did you leave the phone with special agents at the GBI?
Yes.
Same question with the other phone of Jose Ibarra's. Did you search that phone that night?
No, I did not.
That's all I have, Your Honor.
Questions?
Yes. Good morning.
Good morning.
Do you own an Android phone yourself by any chance?
I have in the past. I do not know.
Okay, and I have two at one time. My sister does now. Is it true that you can actually put phones in airplane mode without unlocking them?
It depends on the device.
But there are certain devices that can. You can put them in airplane mode without trying to get into it.
Sure.
And you do that by swiping down from the top and hitting the airplane symbol.
Sure.
Did you try to do that with this device?
Yes.
And what happened?
I believed it wanted me to put in a password to unlock the phone to put it in airplane mode.
So it would not let you put it in airplane mode from the lock screen?
No, it did not.
So then you attempted to get into the phone?
Yes.
And you attempted to use a pattern to unlock it?
Yes.
And that pattern was provided to you by Rose Bailey?
Yes.
Rose Bailey was not the owner of the phone?
No.
You did not have permission to go into the phone?
No,
No further questions?
Did you go into the phone?
I did not.
Thank you.
Anything else?
No, Your Honor.
Excuse me.
Yes. One more briefly. Special Agent Candace Hunter.
Candace Hunter, Special Agent.
Raise your right hand, please. Do you swear from the testimony you will give today in the matter of the state of Georgia versus Jose Ibarra is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Please take a seat. Where do you work?
I work for the FBI in Atlanta.
What is your title?
I'm a special agent with the certification of digital forensic examiner.
How did you obtain that certification, and how long have you been a digital forensic examiner?
I've been a forensic examiner since 2008, and the certification process is about a 2-year process of training, different trainings, both through the Bureau, through vendors, and different agencies.
Are you familiar with Celebrate Premium?
Yes.
Could you tell us how you're familiar with that product?
We acquired a premium in 2021 in Atlanta to utilize to get into we use it for both platforms now, but into locked phones, both Androids and sometimes occasionally Apple devices as well.
And how many times do you think you have had the opportunity to place a phone on Celebrate Premium and extract data from that phone?
Approximately 100.
I want to ask you specifically about 2 phones that came to you to be extracted in the case of State of Georgia versus Jose Ibarra. And those were phones that were labeled by your agency, the FBI, as 1B7 and 1B8. Are you familiar with those phones?
I am.
I want to specifically ask you about 1B7. When did 1B7 come to you for extraction?
It came to me on February the 27th that afternoon.
When you received 1B7, was it locked or unlocked?
It was locked.
What type of phone was 1B7?
It was a Samsung A14,
What kind of lock did 1B7 have?
a pattern lock.
So with 1B7 being locked, could you have searched the phone without Celebrate Premium?
No,
Why not?
I couldn't get into the device without having some tool to guess the pattern lock to unlock the device. So there was no way to get into the specimen without using Celebrate Premium. There are other tools on the market, such as Gray Key, but we did not have an Android license for the Gray Key. So the only option I had was Celebrate Premium.
Was the phone in airplane mode?
No, it was not. I tried to put it in airplane mode upon receipt, but some phones will not allow you to put them in airplane mode if they are locked. And this particular one would not allow me to place it in airplane mode.
So how did you go about extracting data from 1B7?
So first, what I did is I removed the SIM card from the specimen, and I extracted the SIM card in order to obtain the associated phone number for that device. And then I took the phone itself and attached it to the premium for it to attempt to break into the phone.
And did you do these things only after receiving a search warrant to extract data from the phone?
Correct. I met the individual that brought the phones to evidence, I believe around 3 o'clock that day, and they came with the warrant. So I was able to review the warrant prior to.
And when you say break into the phone, what do you mean by that? What happens?
So the software, it has different ways of doing it, and you would have to speak to someone specifically from Celebrate Premium to tell you exactly how it does it, but it guesses different patterns and different, if it was a passcode, it would guess different passcodes without, like if you just physically did it, there's sometimes you will hit a max password of, oh, you've attempted 3 times, now you have to wait a certain number of times. The software is able to defeat that. So it's able to guess more than just, let's say 3 times, to guess different passcodes to see if it can get into the device.
When, was Celebrate Premium able to get into the device?
Yes.
And were you able to do an extraction of the phone?
Yes.
When you are extracting data from 1B7, you read the judge's search warrant.
Yes.
Is that right? Told us. Can you tell Celebrate Premium, I only want you to extract this date range from this phone. Don't extract anything else from the phone. Can you do that?
No, it's a full file system extraction that's obtained from the phone.
And why is that?
Because that's the most complete extraction that we can get, and then the agent or the investigative team can do their review that's pertinent to the warrant to select the items that are relevant.
And may I approach the witness, Your Honor?
Yes.
I am handing you, it may already be up there. Do you see Defense Exhibit 2?
I don't see any exhibits.
I'll give you my copy of it. Oh, you do. Sorry, better you do it. Yes, Defense Exhibit 2. First of all, you know what ribbon data is?
Yes,
What is it?
it is basically Samsung's internal information that they are using to keep track of the device itself. So it keeps all kinds of data about the device in order to make it a better user experience for the user. So Apple also has this. Some people are familiar with the Knowledge C database. So it's similar to that if you're more accustomed to Apple products.
Can you go to page 3 of Defense Exhibit 2? I'm sorry, wait, did I do it? Yep, Defense Exhibit 2, page 3. And do you see line 23?
Yes.
Okay, and that's just, it says display on, off, on. Does that mean that someone was physically touching the phone and turning the phone on and off?
Not necessarily. It's definitely not turning the phone on and off. It's the display coming on and off. But there are many things that would cause the display to come on and off. One could be a user picking up and lifting. So you can set the settings in a phone to awake and the display to come on when you lift it. You can set it to just like the screen to flash, or even a sound to come on when you get a certain type of notification. Those are all customizable features that the user can set in the settings, but it does not necessarily mean that the actual person was moving the phone or anything.
What else could cause the display to come on?
Other than lifting it up and notifications and
So if you have received a notification, like a WhatsApp notification.
yeah, any notifications, you can set it to come on just with anytime you receive an email or anything like that.
And since 1B7 was not in airplane mode, would it still be able to communicate with the tower? Or,
Yes, well, in this case, it did come in a Faraday bag, which is our way of trying to prevent that, and we do try to put it in airplane mode so that we do try to prevent that. But it also came attached to a charging device, which almost acts like an antenna. So even though you're trying to prevent it, which is the best that we can do, it still could potentially communicate with the tower. So, and
go ahead.
I'm sorry. And then that's why also I went ahead and removed that SIM card to either try to attempt further to prevent those tower communications when I hooked it up to the premium.
And so every time that we see in Defense Exhibit 2 this Rubin data, that is also could be the phone just talking to the tower, right?
Yes.
Okay. And that doesn't mean someone searched the phone, is that right?
Correct. No one could have searched this particular, if we're talking about 1B7, no one could have searched it because it was locked.
And then finally, I want to ask you about Defense Exhibit 1. Were you asked to look to see if there was a particular app on 1B7 called Third Eye Intruder?
Yes, I was.
And may I approach the hand first? Thank you. Sorry, may I have Defense Exhibit 1? Did 1B7 have an app on it called Third Eye Intruder?
Yes, it did.
And what is Third Eye Intruder?
This particular app is made by, the vendor was Ashnatech, and it can be used for a couple of different things, but it will take a screenshot of an individual who is attempting a passcode or to unlock a phone, or I can't necessarily say they were trying to unlock the phone, but something touched the pattern on the screen and then took a picture of the individual. If you have configured it to do that, so it can be set up to do that, yes.
And regardless of who may have touched the phone or tried to enter the passcode into the phone, when the phone came to you, the phone was locked.
Correct.
And you were the person who had to unlock it.
Using Celebrite Premium, yes.
And could anyone unlock it other than Celebrite Premium? Well, prior to you, I'm sorry.
Possibly the gray key could have, but I can't say that it would have been successful. I don't know because I didn't attempt that.
May I have one more right now?
Yes.
That's all I have. Thank you.
Good morning.
Good morning.
Agent Hunter, are there other programs besides Celebrite and Gray Key that can unlock phones, or are those the only two?
Those are the only two in the FBI's possession in our lab.
But there are others that kind of exist in the world outside of your possession.
Possibly. I'm not familiar with any other products.
Is Gray Key able to extract parts of a phone, or does Gray Key also perform a full system extraction?
Full.
And you mentioned Cellbrite Premium. Are there other versions of Cellbrite?
Absolutely.
And do those other versions of Cellbrite extract less than the full file extraction?
Yes.
And I want to talk about the difference between that. So a full file extraction will include data that has been deleted from the phone, right?
Correct.
And in this case, some of the data that was extracted in this full file extraction didn't have a date associated with it.
Okay.
Okay, you didn't review the phone?
No, ma'am.
Okay, well then I won't ask you about that. Is the same true for Gray Key? If you do a full file extraction, it will also pick up hidden files?
Absolutely.
Okay, and that includes deleted files?
Correct.
Okay. Let's see. I don't have any other questions, thank you.
Okay.
Why did you have to use the premium and not just regular Cellbrite?
Well, it was locked, so I couldn't use the regular Cellbrite, which that's an advanced logical extraction, would have been my only possibility with the regular Cellbrite, and I needed it to be unlocked.
Thank you.
Just to clarify though, you did say you're not sure Gray Key may have also been able to.
Yeah, so this gets into a little bit of budget issues, but there's a pricing difference to purchase the Android feature on the Gray Key, and we only have the Gray Key for Apple.
So the reason you had to use Cellbrite Premium was because of government budget concerns?
Correct. We have the premium we use for Androids and the Gray Key that we use for Apples.
Understood, thank you.
Anything else?
Not from the state, sir.
Can she be excused?
Yes, sir.
Yes.
Yes, she's excused.
Okay.
Anything else in the way of evidence?
Not in the way of evidence from the state.
Nothing else from the defense, Your Honor?
Y'all want to do argument related to this now?
Yes, please.
If we can, Your Honor. Who would you like to proceed first, Your Honor?
This was the state's original motion. They go, you go,
Yes, sir.
they go.
Well, yes, sir. This evidence that we presented today is in response to the defendant's amended motion to suppress, which was filed after our last hearing. And in that motion to suppress, the defense alleges that they had evidence that would contradict that the phone was not searched or that the phone was searched prior to the warrant. So let me say that the other way around. I apologize. The state's position is, and the evidence has shown, that while 1B7 and 1B8 were seized without a warrant, which we have already covered the last hearing, and I don't wish to cover unless the court wishes me to recover that. Okay, thank you. That those phones were not searched until a search warrant was obtained. And in fact, you've now heard, and you knew from last time, there were 2 search warrants, 3 total, but for each phone. 2 warrants for the phones. We are here today because the defense filed the amended motion saying that they had evidence that that's not true. And I think the evidence has been really clear in the hearing today that what happened to 1B7 is that Special Agent Karate tried to put it in airplane mode, couldn't. The phone was locked. He couldn't unlock it. He didn't search it. It was left with the GBI. Eventually, it made its way to UGA PD, where Agent Hipkiss picked it up, not in airplane mode, and in a Faraday bag. And then it had to be physically broken into by Cellbrite Premium. There's no way it is even possible, and the evidence is uncontroverted at this point, that agents, law enforcement officers, or anyone could search that phone prior to Judge Stevens signing that warrant on February 27th. It's clear from even the own Cellbrite reports that the defense made and put into evidence. Candace Hunter at the FBI was the only person who could open that phone, and she did so only after receiving that warrant from Judge Stevens in the manner in which has been described to you. I hear this complaint coming that they exceeded the scope of the warrant. Well, let me tell you who exceeded the scope of the warrant. The defense did. The first time Special Agent Hipkiss even saw data that predated what Judge Stevens allowed him to take is when the defense created those exhibits and gave it to him. He testified to this court, and you will, I'm sure, in camera review his seizure report. And his seizure report was set at the parameters in which Judge Stevens authorized him to search. And he was permitted to look at items which had no date on it to determine whether in fact they fell within the scope of the warrant. And if they did not fall within the scope of the warrant, he didn't tag them. If they did fall within the scope of the warrant, he tagged them. And tagging them really is just their way of saying he seized them. And they are in those reports that have been admitted to you as State's Exhibit 31. From the plain language of Judge Stevens' warrant, he allowed the FBI to download the entire phone. Not only does it make logical sense that that's the only way they could do it. So it would be like saying, I guess the defense is trying to tell this court, and I'd like to see some legal authority on it, that you can search the phone, but we're just not going to allow you to download it. well, then you're back to what Special Agent Hipkiss said. Well, we're just going to have to physically go through the phone. And if you do that, then you're absolutely looking at everything in the phone. There is a tapestry of cases out there, and I'm happy to provide them to the court about this theory. And it's not a new theory. And I would say that defense's argument is rather novel. There's definitely no evidence that somebody got into that phone before it was cracked. So there's just no evidence to support that allegation. But what they're trying to tell this court is that, well, you're going to have to search the phone without unlocking it. There are cases out there when it comes to computer searches. And in Riley v. California, when we first started this cell phone journey a long time ago with the United States Supreme Court, they likened, and Judge Roberts likened cell phones to microcomputers. And when searching computers, and I think all the case law associated with the search of computers is very helpful here. And I guess my argument is two things. One, they didn't exceed the scope. Judge Stevens authorized exactly what happened here, and they processed the warrant in the way that he authorized it. And number two, if they think that the scope succeeded, we're not using anything that's not in Special Agent Hipkiss's reports, so it's moot, and there's no harm. And three, and finally, they're asking you to establish some kind of procedure where you're allowed to search a file cabinet for the tax returns from 2020, but you can't look at all of the other items in the file to see if they are in fact the tax return from 2020. I mean, if you want to just relate it to other objects or relate it to computers. And so for computers, and I have a few cases to cite for the court, and I can provide them in writing as well if the court wants a brief on it. But quite frankly, United States versus Kahani, Khani, at 502 Fed 3rd at 1281, you can endorse, and this is an 11th Circuit case from 2007, endorses a search of a computer where they eliminate files that are unlikely to contain material within the scope of the warrant. So basically, what the federal courts have acknowledged, and what the Georgia Supreme Court also has acknowledged, is that clearly you have to look at everything within the files to see if it's within the scope of the warrant or not. And if the court would like further briefing on this, and I'm curious to see defense's case law on this because none of it was in their amended motion, I'll be happy to brief it at a later date if the court wants further briefing.
Ms. Beck?
Yes, Your Honor. So first of all, in our motion to reopen the evidence, we did not allege that we could prove the phone was searched. What we said was, at the last hearing, the state alleged the only reason the phones were seized without a warrant was to keep them safe and prevent any sort of tampering. And that's what the evidence today has disproven. The phones were not kept safe, number one. They were tampered with, number two. Agent Karate said that he tried to access the phone. He was caught in the act by the third eye intruder. It may be that he was only trying to put an airplane mode, but the point of the matter is, without a warrant, they tried to enter Mr. Ibarra's phone. That is exactly what our case law prohibits them doing. All of this could have been prevented if they had just, before they seized the phones, gone back to the court and gotten a warrant to seize them, to put them in airplane mode, to search them. All of this would have been circumvented. The same goes for the software that they use to download the phones. You know, I sympathize with the agent's contention that there is no way to limit Cellbrite Premium. But number one, Cellbrite Premium is not the only software they could have used. They chose to use it because of budgetary concerns. And number two, all of that would not be an issue if they had been clear with the judge who signed the warrant that that's how it was going to happen. If they had said, Judge, you know, we cannot limit the data we extract, it's going to be everything, and then we will set up a reviewing team to screen out the data that was unauthorized, and then we'll have other agents review the data that was authorized, we wouldn't have an argument. But they didn't do that. There is nothing in their affidavit to the judge that suggests, Judge, despite the time limit you impose in your search warrant, we are going to get everything. And they didn't do the system that is generally recognized by case law, where you have some agents review the phone and separate out the data that was lawfully seized and unlawfully seized, and then you decide, the agent's working the case, what you're going to seize. The same agent did both. Agent Hipkiss filtered the data himself, and then Agent Hipkiss decided what was within the parameters of the search warrant to seize it. The last thing I would point out, Your Honor, is that the state and the agents are trying to make this distinction between authority to search and authority to seize. And I don't think that that is in line with the warrant. The warrant is, you may search data within January 1st of 2022 to the present, and you may seize data within that time range. There is no, you can search everything but only seize the data within that time frame. So their distinction is a distinction without a difference, because the search warrant is talking both about the search, which is the extraction of the data from the phone, which was everything, and the seizure. And this last thing on that point, Your Honor, is that the state is saying we only seize data within the time frame. That's not true. Agent Hipkiss said that there are images in his report that don't have a date at all. There is no way for the state to verify if those images without a date associated with them happened, were deleted from the phone within the date range authorized by the warrant or external to it, because there's no data. So we can't trust with confidence the state is only using evidence within the authority of the warrant. And then the last point on this, Your Honor, is that is all about how the search warrant was executed. But our original argument, which we stand on, based on State versus Wilson, 315 Georgia 613, is that the search warrants were overbroad because it authorized what the government contends. It authorized a full system extraction for deleted data that could not be contained by any date range for 10 devices without identifying which device belonged to which defendant. That is the definition of an overbroad warrant. There is no limitation as to the data the state could have seized based on their interpretation of the warrant they got. And so for that reason, Your Honor, we ask that Your Honor grant our motion to suppress, or at the very least, limit the data that the state can use at trial to the data time range authorized by the warrant.
You want to be heard any further?
Well, I mean, a little persnickety, but
Not inviting you to restate this.
no, but just the phrasing of defense counsel, well, maybe he tried to put it in airplane mode. If defense counsel has evidence to contradict what the record is in this case and the testimony of it, now's the time. Because what the evidence is that he did try to put it in airplane mode.
Thank you. We'll go to the next matter.
And Jeff, is that the 702 on the true audio, or do you want to take up the fingerprint argument?
I'm going to leave that. I'm thinking the DNA dollar motion would be next.
Okay.
Because I imagine there's people that are involved in that just need to move on. So.
And Judge, I don't have any idea what the state's presentation is on that. I would ask to be heard on the motion to continue,
Okay.
obviously prior to this going on. And so I can take that up now.
Now is
Okay. Judge, I would. We're here on the motion to continue filed on October 25th by the defense as to the 702 motion on the Truralio. We had, as the court is aware, we had filed a motion to continue that had been granted by the court prior to the October 11th scheduling for that 702 hearing for the Truralio. The reason for that is that we didn't have any of the underlying data which could be analyzed, evaluated, or otherwise looked at, even by an expert if we had one. And so the state agreed to that continuance, the court granted it, and we are in the same position that we were before. We were given access to the underlying Truralio data and underlying DNA data at 5:30 on October 10th. And having spoken with an expert in this case, we would not be prepared to have anyone look at that or be done looking at that and to be able to assist us in our evaluation and challenge that evidence for at least 6 weeks. Now, that is not our doing. That is not the defense's doing. That is not Mrs. Ross or Ms. Ross's doing. I believe that is perhaps just a circumstance of this case. But it is necessary for us to be able to proceed with this motion, to be able to consult someone who's an expert in this field. The amount of information, number one, is voluminous. And in terms of the ability to sift through that data in the time frame that we have been given, which is, let's call it 2 weeks, 2.5 weeks, is unreasonable. The complexity of that data is beyond the scope of certainly my ability to understand without the assistance of an expert. And as far as I know, the assistance of anyone on the defense team in terms of our training in math, in probability, statistics, as well as computer science, that will be what I believe will be presented by the state in this case. There is also a novel aspect of Truralio that is pertinent to the court's decision to grant continuance in this case. As far as I can tell, there are 3 cases in Georgia from the appellate courts that have addressed Truralio at all. The only one that does that in any substance is Gates versus the state. That's 308 Georgia 238, a case from 2020. I don't have these cases printed out. I'm sure that Ms. Ross is abundantly aware of them and familiar with them. Having done a case that took them a year to just prepare for one challenge to this test. But Gates, as well as Smith versus the state, 315 Georgia 287 2022 case, involved extraordinary motions for new trial where the defense was introducing true allele, and that was not challenged by the state. The state had not objected to the introduction of the evidence, and the argument in those cases was whether or not that true allele evidence, not the scientific basis for it, but whether or not it constituted new evidence for purposes of the extraordinary motion for new trial statute. The appellate courts in Georgia had not ruled on the admissibility of this science or math or computer program that the state is using to analyze underlying DNA evidence. And the only other case is Nunger versus the state, which is 316 Georgia 1, 2023 case. And that ruling came down to an issue as to whether or not the defense had preserved an objection about true allele that was decided under the Harper standard. And so I don't think that it is particularly applicable to the admissibility of true allele under Dahlberg. And the fact is that those first two cases that I mentioned really highlight the novelty of this science, as the appellate courts have outlined it, which is that they were ruling that it was new evidence. It was a new type of evidence that was not able to even be used by the defense, and such that it allowed them to proceed on an extraordinary motion for new trial. And without the ability to hire an expert and to have an expert evaluate this case, there is no way for us to effectively cross-examine any of the witnesses in this case. I've looked at it. I have tried to understand what that data is, and I am unable to do so. So, Judge, as to cases that are out there right now, and I believe that Ms. Ross would be familiar with the Deeds case, I think it was Dodge County. That case required a year's worth of preparation with expert witnesses and a week's worth of litigation just about the science of this. And that the amount of time that we have is obviously nowhere close to that. So I would like to just offer a proffer for the court as to the timeline of when the defense began asking for this evidence. In mid-August, the defense mentioned this to Ashley Hinkle, who was the GBI agent who handled the cases. She told us that we needed to go through their open records department. On August 19th, the defense made a request through the open records department to get the underlying DNA and true allele data. That request was denied by the GBI because the testing was not completed in the case. So that would have put us in late August for this. The GBI informed us that they expected the testing to be done by September 2nd, 16th. Ms. Ross helped us in trying to get this open records request done. We offered to limit the open records request to 3 or 4 tests that were done in an effort to speed that process up. We were assured that we would get that information around late September 23rd. The GBI says that they would see what they could do about expediting that process. And we didn't get anything back until October 10th. I can wait for the introduction of the test, but I don't think that this will be in dispute, and I will offer it as a proffer to the court. I think Ms. Ross would be able to comment on it. The tests that were done that were specifically limited in the open records request, all of those tests had been completed by if I could just look here, Judge, June. I believe the latest test that I have here would be a true allele report. They were given an item number 56, and that would have been done on June 10th of 2024. And so, Judge, the fact that we were not given this information until 12 hours, 15 hours before we were scheduled for a motion, again, I don't believe is Ms. Ross's fault, but it doesn't allow us to effectively evaluate or confront the evidence that will be presented to the court today. We're making a request for a continuance and would object to going forward based on Sixth Amendment right to counsel, to effective representation of counsel, Fifth Amendment confrontation.
That's my sign to turn on the air conditioner.
Okay. Fifth Amendment right to confrontation, due process considerations, and any corresponding pieces of the Georgia Constitution. This is not made for delay. This is not made for purposes of delay. We would like to be going forward with this, and I can tell the court in my place that we have made every effort to consult with and talk to lawyers who are more familiar with this information than we are. And at each step of the way, they have told us that this cannot be done, that it is not reasonable for this to be done, that we need to hire an expert. And we need to have an expert evaluate this information. And there are reasons for that. There are reasons for that even from a cursory review of someone who is more familiar with this type of information than certainly any of the defense counsel is. I would just ask the court, and what I would present to the court is Does my approach?
Yes.
Thornton versus the state, which is 255 Georgia 434. I presented this to the court because I think that it is helpful in deciding the issue as to whether or not there is a right of a defendant to have the assistance in evaluating and understanding evidence, especially evidence that is not. This is a 1986 case, and it is about dental records. It is about the use of dental impressions and whether or not a defendant has the right to have an expert evaluate dental records. At the time, that was a novel approach to forensic science, and the court said that where a defendant has made a timely request, and pre-trial, I believe, would be a timely request for that expert on a novel type piece of evidence that is critical to what the state is going to present. They are entitled to an expert. McWilliams versus Dunn is a Supreme Court case, and that is, I don't have the U.S. site judge off the top of my head, but it is 137 Supreme Court, 1790. It's a 2017 case. It is decided under ACI, which I recognize has to do specifically with psychiatric evaluations and experts being required under certain circumstances. But I believe that the logic and the reasoning behind that would be the same, which is that it is necessary for effective representation for the defense to be able to understand evidence, and without that understanding, it is impossible for us to be able to say whether or not what is going on is true or not. And due process requires that if the state has access to these experts, that we also have access to these experts. And I don't want this to go any longer than it has to, but this is very real in terms of the ability for us to understand the information. And so we'd ask the court to continue this hearing.
Ms. Ross, do you want to be heard?
Yeah, I will just put a few of the things that defense counsel said in context. First, number one, as noted in the state's bench brief in support of the admission of Trujillo, which I filed on September 11th of 2024, I think what the lawyers are having a disagreement upon is the definition of the word new. Trujillo is not new. It's been around for over a decade. It's new-ish to Georgia. We've been using it since 2018. That's still many, many years that it's been here. The fact that the Georgia Supreme Court has only mentioned it 3 times in passing, coincidentally enough, in cases in which Trujillo exonerated people and the state didn't contest the reliability of the evidence, it's just not new. The federal courts have been dealing with Trujillo and probabilistic genotyping in general for a long time, as laid out in my brief. There's another program that the court will hear about called StarMix, which also uses probabilistic genotyping. But there are federal cases right on point about Trujillo and its admissibility and its reliability. I think the court would be, and I have to separate, I guess, the Daubert from trial in my mind. I don't even know if it's an appropriate separation, but for the Daubert, the court would be within your rights to take judicial notice of true allele, as some of your other colleagues have done. I attached to my motion a court order from Layla Zahn, the Honorable Layla Zahn, where she actually just reviewed a transcript from federal court, which was in the Northern District of Georgia, of a Daubert true allele challenge in 2019, and took judicial notice of true allele. So I don't think true allele is new. They asked for a Daubert in August is when they filed for a Daubert. And to back it way up, it was very apparent early on, and I can just for the record here. That April 3rd of 2024 is the first true allele report issued by the GBI in this case. But they would not have gotten it until the first round of discovery, which would have been in May of 2024. So it's very obvious this is a true allele case from the first round of discovery. They filed for a hearing in August. And I am sympathetic towards them about the raw data. It was difficult to get for many reasons. But the last true allele report in this case is actually September 10th. Of 2024. And the GBI can't give people raw data on cases that are not complete. So this case was not complete by GBI protocol until September of 2024. We did diligently work together as quickly as possible through both open records requests, which I can apparently file on an open case, and a subpoena, which they could apparently, they did drop one, and we worked together to try to get them the data as quickly as possible. And they do have the raw data, and I do think they're entitled to look at the raw data. They have it. But as far as, that's why I think for the Daubert itself, and when you file a motion in August, and it's a general motion, just saying we're challenging true allele, it's new. I filed a response, it's not new. You can take judicial notice of it. I would urge you to take judicial notice of it. We don't need a Daubert on it. That's a different matter to me than what they eventually want to do. But I will tell you this, because he brought up the Deeds case. This is nothing like that case where there's 10 picograms of data, or it's just nothing like that. There's nothing like that case. We can't bring up that case to say, oh, this is so complex. There are judges in this state, because we have been doing true allele Harper challenges and now Daubert challenges for years, 6 years in this state. And to this date, there is not one Superior Court judge in this state that has found true allele to be unreliable. So I understand what they're saying. I'm going to leave it to the discretion of the court. I just wanted to put the timeline in context and put in context with the court what the state's position is, which was in writing, and now, which this is not a new science. You could take judicial notice of true allele before the Daubert hearing, but because they asked for the hearing and the hearing is scheduled, I have my witnesses here. I will put up my witnesses to make a record of true allele and what it is and what it does and how it works, and then I'll wait for the court to enter a ruling.
You need to be heard any further on the motion.
Judge, the only thing that I will say is this:
Will this be something new?
well, as it relates to the time frame, I think that it is because I think that is a very important aspect of this, and the ability to file a specific motion in this case is impossible without understanding what the underlying data is and having someone tell us what it means. I cannot understand this, and I don't think that it is reasonable. I don't think that Ms. Ross could get up and say, any other lawyer could learn this in 2 weeks, knowing what she knows. It is impossible for me to do it. I've tried. I've spoken to people who are familiar with this. I can't do it.
All right. For today's purposes, I'm going to offer you to go forward with your showing on your expert, unless there's some stipulation about that. Just offering that. About your Daubert expert. You need to go forward with.
Well, once they file the motion, if judicial notice is not taken, then it is my burden to go forward, which is why I have my witnesses here and I'm prepared. I'm happy to take a break and discuss with the defense counsel a stipulation of sorts, but I'm not sure, by his face, I'm not sure we're able.
I'm always happy to talk. I don't know what it could be, but I won't say no without hearing.
Let's go forward.
Yes, sir.
How long is this going to take?
This first witness is going to be, I think, a longer witness, so maybe take either a quick break or, and then decide. I think it should be about an hour. So if you want to, can we just take a quick courtesy break and then do lunch or not do lunch? I don't care.
I'm looking to not do lunch.
Perfect. May we just have a 10-minute break then?
Yes, 10 minutes. Thank you.
Oh. Can you raise your right hand, please? Do you swear or affirm the testimony you will give today in the matter of the state of Georgia versus Jose Ibarra will be the truth, the whole truth, and nothing but the truth?
I do.
Where are you employed?
I am employed at a company called Cybergenetics, which is located in Pittsburgh, Pennsylvania.
What is cybergenetics?
Cybergenetics is a technology company that develops and uses the Trulio casework software that's used to interpret DNA data.
How long have you worked for cybergenetics?
I've worked for Cybergenetics full-time since 2012, so about 12 years now, and I was an intern for a year before that.
Tell the court a little bit about your education and your background.
I have my Bachelor of Science degree in biology from Duquesne University, which is located in Pittsburgh. I also have my Master of Science degree in forensic science, also from Duquesne University.
Have you, tell us a little bit about your day-to-day duties at cybergenetics?
So at Cybergenetics, I'm the casework manager, and that just means I'm responsible for overseeing part of our DNA data processes. So with Cybergenetics, we have two parts. We have a service part where agencies will send us data to run the Trulio software on, and then we also have we sell our software to other laboratories like the Georgia Bureau of Investigation Laboratory and others in the United States. So I'm responsible for just part of our internal casework process, analyzing that data, writing reports, and then testifying in court about Trulio results.
Have you analyzed Trulio data before?
Yes, I've analyzed DNA data using Trulio in about 1,000 cases.
Have you testified to your results before in court?
I have.
Approximately how many times?
57 times.
Have you been declared or qualified as an expert in the field of DNA evidence interpretation before?
Yes, I have.
Approximately how many times?
In the 57 times I testified.
And can you tell us a little bit about the number of cases that you have worked in the Trulio software for?
Sure. I've analyzed about data from 1,000 cases and then probably close to 3,000 different evidence items.
And Your Honor, this time I'm going to may I approach the witness?
Yes.
Manny, what's been marked for identification, that states exhibits 32, and then 33 and 34. I'm just going to leave them up here so I don't have to walk back by. Do you recognize 32?
Yes.
What is it?
It's my curriculum vitae.
Your Honor, at this time the state would move to admit states 32.
Okay, good.
32 submitted.
And at this time also the state would tender Ms. Bracamonte as an expert in the field of DNA evidence interpretation.
Any objection?
Judge, I don't have a way of evaluating that. It certainly seems that she's more qualified than I am.
I will take that for what it was announced. I will allow the witness to testify as an expert in DNA evidence interpretation.
I would like, if you could, to explain to the court Trulio and how it works and whether it's reliable and reproducible. So to do that, you have prepared 2 PowerPoints for today, and do you remember that?
Yes.
Okay, and are they in front of you as States Exhibits 34 and 33?
Yes, they are.
Could you first start with States 33? What is it?
It's a PowerPoint that explains the overview of the Trulio process, some of the background, how it works, and how the results are presented.
And the state would move to admit States 33.
Any objection to 33?
I'm sorry, is that
It's the first one. It's a smaller case.
Judge, I don't. Judge, I'll leave it to the discretion of the court. I think that this would just be demonstrative aids in terms of what Ms. Bracamonte's testimony would be. I don't think that we need to admit this into evidence.
She's asking for it to be. I'll admit it. I mean, I'm the only one that's going to be seeing it
Yes.
at this point. So it's not in the trial.
I understand.
And
That's a
state,
better way for it to be part of the record, in my view.
yes, sir. And that's why I'm moving to admit it.
And I will. 33. And is it 34 another PowerPoint?
Yes, sir. States 34, what is it?
It's a PowerPoint that goes through Trulio's validation.
And did you prepare that PowerPoint in preparation for your testimony today?
Yes.
State would move to admit States Exhibit 34.
Same thing, Judge.
I understand. The objection is noted as far as admitting the evidence. I will consider that and admit 33 and 34.
If we could, Judge, they are admitted for the record. I think an easier way to display them so that defense counsel, the defendant, and the court can see is just through the overview. There are no case-specific references to any of these PowerPoints, so I would just request to play it that way. It'll just be easier.
No objection, Judge.
That'll be fine.
So let's start then, and may I approach the witness and give her a...
Yes.
If you could hand it to a pointer for the record, we're starting first at States 33 at page 1. It's just a cover sheet?
Yes.
Right, okay, so let's go in. Tell us what is true allele.
So starting off with some of the basics, starting with DNA biology, the human body has trillions of cells, most of which have a nucleus that has all of our DNA that's wound as chromosomes, and there are specific regions on those chromosomes or locations that are useful for identifying people.
Okay. And go ahead. So does true allele start with traditional DNA analysis?
It starts with the data produced by that traditional DNA analysis.
Okay, go ahead.
And so those regions that are useful for identification are called short tandem repeats. And all they are segments of our DNA where there's some repeated DNA fragment, some number of times in a row. And the number of times that that segment's repeated corresponds to an allele number, which is inherited from our parents. And labs count up that number of repeats and use that number to identify people. Because it's not only 10, it could be there's 10 to 20 different possibilities in any one location for that allele number.
Okay, go ahead.
And so we get one allele from our mom and one from our dad. And so at every DNA location, there's a pair of alleles. So here in the example, maybe at 10, 12. And that would be what's called the genotype at one DNA location. And so it's not only 10 and 12 in every person. These regions are variable, so somebody could be 13, 14, somebody could be 15, 16. There's about 10 to 20 different allele possibilities, which results in about 100 possible pairings of those alleles. And then that's just at one location. So testing the 20 or so different locations makes a person's overall genotype relatively unique.
And how does true allele use the data from a genotype? So tell us about it.
So with simple DNA, like DNA from one person, the lab takes that sample, they extract the DNA, make many copies, and produce the data that we see in the middle. And when it's from one person, you'd expect to see no more than 2 allele peaks. And so looking at that data, a person or a computer can then say, well, the genotype at this location would be at 10, 12, because that's what the data is showing us. There's nothing at 9 or 11 or 13. And so then with simple DNA, you can just compare that with a known reference and calculate a match statistic.
What is a known reference? What are you talking about?
A known reference would be like a swab from a known person, so like a cheek swab or something that we know came from that person.
Okay. And so that's simple DNA. What about a mixture?
So with DNA mixtures, which are just samples that have more than one person's DNA, let's say in this example, maybe there's 2 people, the lab does that same process to produce that evidence data that you see in the middle. But now there's more than 2 peaks, which indicates a mixture. So now it's a little bit trickier to say, all right, which of these alleles pair together for each of the people? So let's say, but the data still guides that interpretation. So 10, 11, and 12 are the possibilities for the alleles at this location, because that's what the data is showing. So let's say we know one person's a 10, 12, and maybe it's a swab from their body, and there's somebody else's DNA there. Well, what's the genotype for that second person? Looking at this data, that second person must have an 11, because that's not explained by the 10 or the 12. So pairing that 11 with 10, 10, 11, with itself, because you can get the same number from both mom and dad, or with 11, 12, that list of allele pairs is then given some probability or just how well they explain the data. And that's the evidence genotype, that list of allele pairs and their probabilities. And then that in the same way can be compared with a known person's DNA, and it would just reduce what that match statistic would be in the end.
And does the computer do the analysis in true allele?
Yes.
So tell us about that.
So what true allele is, it's a computer technology that uses all of the DNA data to work out the different contributors that are there. So in this picture, this is what DNA data actually looks like at one location. Along the bottom is just the size of that DNA fragment, which then allows the scientists to know what those allele numbers are on top of each of those peaks. And then along the left, the height of each of those peaks corresponds with the amount of that person's DNA that's there. The taller the peak, the more of that allele that's there. Smaller peaks, there's less DNA. And there's an overall pattern, highs and lows, and variation. And the computer uses all of that information to work to separate out the different genotypes based on the data.
And was this at one point done by people before true allele?
Yes.
Okay, so tell us about the difference and go to the next slide.
So with prior to computers, what people did to simplify the problem, they basically drew a line through the data. And anything above that line they'd consider, anything below was discarded. So, and what's been seen in studies since then, why people are moving to computers is you lose a lot of DNA information by using those thresholds. So in this example, the 17 and 18 wouldn't have been considered by doing a manual analysis. And so that information would be lost.
Okay, and tell us how the computer does it. And also let us know what is the role of a human scientist in true allele?
Sure. So with true allele, it's taking all of that underlying data that a person would upload to it. And then based on their expertise, the analyst reviews that data at every single DNA location to get an estimate of the number of contributors that are indicated by the data. And so they input that number of contributors. In this example, let's say there's maybe 2 people's DNA. And then what true allele does is it works to propose different combinations of allele pairs and assess them against the data and say, well, which ones explain the data better than others? So in this example, maybe I asked Trullo to solve for 2 people. It may say that one person's allele pair proposed that it's a 1718, indicated by the blue boxes. And maybe a second person is a 1519, represented by those orange boxes. And then by comparing those colored boxes, that pattern, to that underlying data, Trullo looks at it and says, the tops of those boxes match up with the tops of the peaks. This is a good explanation of that data. So those resulting combinations, the 1519 and the 1718, would get higher probabilities for each of those respective 2 contributors. And the computer is not just trying out this one possibility. It's trying out thousands of different possibilities, moving the boxes around, changing the heights, and just comparing it all to the data to say which ones explain the data better than others. And then it's not just trying good ones, it's also trying ones that don't look like the data. And that combination would get lower probability in the end.
And after it tries all the combinations, then what?
The result is a genotype, which is just a list of allele pairs on the bottom with their resulting probabilities. And it does this for each of those 2 contributors at every location tested. And this is at that one location we've just been looking at for that blue contributor, that more minor contributor, which was the 1718. And Trullo's doing this just looking at that evidence data, never seeing a comparison reference at this point. And here, with this simpler problem in this example, that 1718 was given a lot more probability than the other option to try it out.
And at what point does the reference sample of potential contributors, for lack of a better term, and contributors are just people, right?
Yes.
Okay. So at what point does a reference sample of a person of interest come into play in Trullo?
After the evidence genotype, that blue bar, has been inferred.
Okay.
So it's only after Trullo's seen that evidence data is a reference ever introduced.
And how many times does a human ask Trullo to infer genotypes in one sample? How many times is it ran?
It's run at least twice to show that there's reproducible results between samples.
Is that also concordant? Is that a word you use sometimes?
Yes. So just referring to concordance, meaning you get a similar result each time the computer's run.
Okay. And then what does it give some type of match statistic?
Yes.
After the process is run. And you say we just looked at one allele pair here. How many pairs does it look at, the computer?
So it's trying out virtually every possible pairing for those different contributors and then comparing them against the data at each location for both of those contributors.
Okay. All right, go ahead. But how many locations are there? That was my question, sorry.
Oh, it depends on the kit that's used. I believe if it's the Global Feather kit, it would be 21 different locations.
Okay, go ahead.
And so after those evidence genotypes are inferred, you can compare with a person relative to the chance of a coincidence. So if you take somebody random out of the population, what's the chance they have that allele pair? And so all the match statistic is just comparing the probability that somebody contributed their DNA or an evidence match versus the chance that it's somebody else or just somebody out of the population. When you have a higher probability of a match versus that coincidence, which is the brown bar in this picture, that gives you an inclusionary statistic. And if it's the other way, where the brown bar is higher than that chance of a match, it's an exclusionary statistic. So Trullo can compare with anybody.
So Trullo can both include or exclude depending on the data?
Yes.
Go ahead.
And then let's say in this example, maybe the person happened to be a 1718. Well, that would give an inclusionary match statistic at this one location of 8 times more probable than a coincidence, because it's just comparing that 93% versus that 12% chance of a coincidence. And then that same process is done across, in this example, it was 15 locations, but it just depends on the DNA testing kit that's used, how many locations it would do this for. Trying out those patterns, comparing them with the data, writing down those evidence genotypes, and comparing against the reference to calculate the match statistic, which is just how far each of those blue bars sticks out. And then by multiplying these numbers together, that comes up with the overall match statistic.
Okay. And is that called a likelihood ratio?
It is.
Can you explain that to us and how it looks in a report?
Sure. So the way the match statistic is written is just a match between the evidence item and the person we're looking at is 11.8 billion times more probable than a coincidence. And all that is doing is just assessing what's the chance that they contributed their DNA versus the chance that it was somebody else. So it's just comparing that ratio of those two probabilities. When that top number is higher or larger than that smaller number, you get an inclusionary statistic. And if it were smaller in the numerator than that denominator, you get an exclusionary statistic.
And how broad of a range can the inclusionary statistics go?
It could range basically, so if 1 would be your middle point, which is no information because it'd be equal, it would go from there all the way out to, it could be 30 zeros after the 1. It could be larger than that, depending on that reference profile and how rare it is in the population.
And what about the the likelihood ratio statistic, if it's higher, does it also mean that the person may have contributed more of their DNA?
Yes. As seen in some of the studies, which we'll talk about, the amount of DNA a person contributed, it can be predicted based, the match statistic can be predicted based on that, so it correlates with that. More DNA from a person, you expect a bigger number. If there's less DNA, you'd expect a smaller number.
And TrueAllele is only used to interpret mixtures, is that right?
It can be used, it's primarily used for mixtures, but you could put a single source sample in and it'll just say, yes, these are the same, essentially.
All right. So tell us how the likelihood ratio relates to the log.
So when you have the likelihood ratio, that number, that bigger number, a different way to represent it would just be the logarithm, or the number of zeros that follow the 1. So when you have a number, of 11.8 billion or so, it would be a 1 followed by 10 zeros. And so it's easier to visualize in some of the studies, which we'll see in the logarithm form, or the number of zeros after the 1, versus looking at, billions, trillions, millions, or so.
And is the likelihood ratio just some kind of hypothetical construct, or does it actually mean that person's DNA is present in the sample?
It relates to, it measures the chance that they contributed their DNA versus the chance that it was somebody else. So it's just weighing those two different possibilities.
But does it mean their DNA is present?
It means that there's statistical, association between the evidence and that person.
Go ahead. And then is there an error rate associated with TrueAllele?
Yes. So there's both an overall and a match statistic specific error rate. And with TrueAllele, we can basically calculate all trillion possible people. And in this image, the bottom just shows that logarithm form, or the number of zeros after the 1, with 0 being no information, 10 being, 10 billion, and minus 10 being 1 divided by 10 billion. And when we compare virtually everybody that could exist DNA to this specific sample, they're largely excluded. And there's a very small chance of a false inclusion. There's nothing to the right of 0 there. And then when we can calculate an error rate based on that for any match statistic as well.
And okay, and is the what is the math based on in the computer for TrueAllele?
The math is a statistical model, so it's based on Bayesian probability modeling and Markov chain Monte Carlo statistical sampling. So just
can you speak a little into the microphone, because it is your voice travels a little bit, so it's hard to hear you.
Sure. Is that better?
Yes.
Okay. It uses, it's a statistical model that uses Bayesian probability modeling and Markov chain Monte Carlo statistical sampling to work out those different probabilities and proposing and assessing those different possibilities.
And are either one of those two statistical modeling things that you just mentioned particularly new?
No.
Tell us why.
The Bayesian modeling has been around since the 1700s, and then as a mathematical concept. And then the Markov chain Monte Carlo has been used since about the 1950s with the Enigma, or during World War II in the Enigma project.
Now, how long has TrueAllele been around?
TrueAllele was first developed in 1999, and then went through about 10 years of innovation and testing, and then was first used in casework in 2009.
And before being used in casework, you mean like forensic casework, like what courts and such like that?
Yes, the first TrueAllele case was in March of 2009.
And we're going to get to it in the next PowerPoint, but before I dig into State's Exhibit 34, has TrueAllele been validated?
Yes, it has.
And what is validation?
Validation is just testing any method on data. So putting data in and reviewing the results, and it's used to see that the system's working as it's proposed to and establish any error rates.
And since TrueAllele has been used in forensic work, casework since 2009, how many TrueAllele reports total from not only your lab but across the country you think have been produced?
Oh, in the thousands or tens of thousands.
How many laboratories are using TrueAllele?
There are currently 10 crime laboratories that use TrueAllele in their everyday casework process.
Has TrueAllele been used in non-forensic settings as well?
Yes, it has.
Tell us about that.
So TrueAllele has been used to identify victims of mass disaster. It was used in 2006 to reanalyze victim remains from the World Trade Center project and compare with family members or personal effects. And it's also been used, it was in a 2009, I think, a bus crash in South Africa as well. And TrueAllele's, also been used to help create some of the DNA standards over time that labs use to test that their machines, like to produce the data, are working as expected.
Has TrueAllele also been used in exonerations?
Yes, it has.
And exonerations in criminal cases specifically?
Yes.
Okay. I want to move to State's Exhibit 34, and it looks like you talked a little bit about the first slide, which is number 2 for the record on the top right corner, but this is explaining DNA mixtures. Can you tell us a little bit about that?
Sure. So the first paper that talks about the TrueLo results, how it does the statistical model, was published in the Journal of Forensic Sciences in 2001 in a paper called Linear Mixture Analysis, a mathematical approach to resolving mixed DNA samples. And this paper focused on looking at p-kite data and showing that it was that sum of genotypes. So when you compare those colored boxes, how that relates to the data. So the underlying basically model behind it was first published in 2001.
And is that a peer-reviewed journal?
It is.
And what does peer review mean in your world? And what is the significance of a peer-reviewed journal?
Sure. So peer review is a process in science where scientists will write up whatever study they're doing, their test of their system on data. They submit it to a journal, which is just a collection of scientific works, and that journal editor will then send it to at least 2 independent anonymous reviewers in the similar scientific field who will then assess the work for its merit and deem if it's suitable for publication or not. And then they'll recommend either the journal publish it, request some edits, or not publish it.
And how many peer-reviewed journals has TrueLo been in?
Well, there's at least 8 peer-reviewed validation studies, and then there are some other articles like about the methods that have been published in some other journals as well.
The next slide about that publication.
This is just again showing what we already saw, that the computer uses all of the data and the variation.
Okay. And I want to go ahead and do slide 5.
Mm-hmm. So with TrueLo, there have been over 40 validation studies done. 8 of those have been published in peer-reviewed journals. The system's objective, meaning it only gets that information from the evidence data, doesn't know, you can't be influenced by human bias at all during its inference process. It's been reported in 46 states and used by 10 laboratories. And then all of the math, the software, invitations to test the system are disclosed in a large Dropbox. And then TrueLo can statistically include or exclude people. It's neutral. It doesn't, try to just find somebody or implicate them in the DNA.
And are these all the peer-reviewed validation studies that you have already spoken about?
Yes. And the top 5 in the lighter blue are done on laboratory-generated data, meaning data that the scientists knew what they put in to establish, the error rates and see how it works when we know what's supposed to be there. And then the bottom 3 are done on casework data to kind of assess how does TrueLo work on that data in the wild.
And the next slide is that Dr. Perlin, who is Dr. Perlin, by the way?
Dr. Perlin is the chief scientist and chief executive officer at Cybergenetics. He was the one that invented the TrueLo software.
Go ahead.
And so the first published TrueLo validation study was published in 2009 in a journal called PLOS 1, and it was titled An Information Gap in DNA Evidence Interpretation. And this was the very first study that was done on TrueLo. And kind of one of the main points that TrueLo showed is that the match statistic is predictable. So along the bottom of this image is just the amount of DNA a person contributed. And then along the left is that match statistic, so what that likelihood ratio is. And what we observed is that the match statistic corresponds with the amount of DNA. When you have more DNA from a person farther to the right, you get bigger numbers. And when there's less DNA on the left, you expect smaller numbers, until the point where it basically gets that single source inference. So it says, this is basically, it kind of maxes out at one point.
That was the first one. What about in 2014?
So in 2014, this would be, I think it's the 4th one in the series, but this is the first one that assesses how you can validate systems like TrueLo and introduces the axes of sensitivity, specificity, and reproducibility. And it was published in conjunction with the Virginia Department of Forensic Sciences Laboratory, and it's just titled, TrueLo Casework on Virginia DNA Mixture Evidence, Computer and Manual Interpretation in 72 Reported Cases.
And I'm going to ask you about sensitivity and specificity and reproducibility separately, but is there are there other probabilistic genotyping softwares out there that compete with TrueLo or do the similar things that TrueLo do?
Yes, there's about 10 other softwares that would be considered, they're called probabilistic genotyping. So they just use, the math and the probability modeling to look at DNA data.
And is StarMix one of those probabilistic genotyping softwares?
Yes, it is. And that's capital S, capital T, capital R, lowercase MIX.
Thank you. Let's talk about sensitivity. What does that mean, and how does that relate to knowing whether or not TrueLo is reliable and does what you say it does?
So sensitivity just assesses, the extent to which the method, identifies a correct person. Are we finding those true inclusionary statistics? And in the study in 2014, we looked at 101 reported evidence genotypes and just said, okay, what are those inclusionary match statistics? And what do they look like from TrueLo?
And what were your results? I'll go back there.
And so,
sorry.
Looking at TrueAllele, on the horizontal axis is just the match statistic and the number of zeros after the 1. And what we saw is that there was a wide range of TrueAllele results, ranging from lower match statistics, maybe in the thousands, out to over 20 zeros after the 1. The average was about a 1 followed by 11 zeros, or 113 billion. And in this case, we had mixture weights, or the amount of DNA people contributed, ranging from, lower amounts, like say 10% to over 90%. And so just based on, the predictability, we'd expect a wide range of statistics.
And did you do a comparison with human review, the same data?
Yes. And so the original studies more focused on how do computers improve over human review. And in this study, there were 2 different methods done, one with 1 threshold, or the CPI method, where you see there's a smaller cluster of those match statistics with an average around 6 million. And then there was a 2 threshold method, or modified CPI, and a lot more information was lost with match statistics, in the hundreds. And with TrueAllele, there were those 101 inclusionary match statistics. With CPI, there were about 80, and with the modified CPI, there were only about 50. So using thresholds limited the results that could be reported from that same DNA data.
What about slide 12?
And so we also examined TrueAllele's accuracy in this study. And so when you have a wide range of mixture weights, you'd expect a wide range of match statistics. So that's what the black line in this picture is, what we'd kind of expect.
What is a mixture weight, real quick?
A mixture weight is just the proportion of DNA somebody contributed. So if you have a mixture of 2 people's DNA, maybe one person contributed 60%, one person contributed 40%, the numbers will always add up to 100%.
Okay, go ahead.
And so comparing TrueAllele's match statistics with what we'd expect, it roughly follows that line and isn't statistically different. But when looking at those human review methods, they differed from, having a wide range that you'd expect when you have a wide distribution of match statistics.
What is specificity?
So specificity allows us to assess the false positive rate. So are we properly excluding people who didn't contribute their DNA? If they're actually non-contributors, are they excluded?
How did you test TrueAllele specificity?
So in this study, there were the 101 evidence genotypes, and we compared with 10,000 randomly generated profiles from the 3 different ethnic populations tested. So there were over 1 million comparisons, and then those were plotted here. Along the bottom is just the match statistics and number of zeros, where you have 0, that's no information. To the right of 0 would be inclusionary, and to the left would be exclusionary. And in this case, most of those statistics, where those colored bars are largely exclusionary, with that average information, exclusionary information for those non-contributors, a 1 divided by a 1 followed by 19 zeros. So very, very small, exclusionary statistics. And then we also looked at what's happening past 0, those small inclusionary statistics.
And is that a false positive?
Yes.
Tell us about that. Sorry.
So in the study with TrueAllele, in the over 1 million comparisons per group, we just looked at anything that was slightly inclusionary for those random people we generated. And so with log LRs just greater than 0, so anything slightly inclusionary from 2 to in this case it was out to 1,000, how many false positives were in each group? So there were about between 40 and 50 total across the 3 groups, so about 150 total. And then most of those were between 2 and 10. They were less than, a likely ratio of 10. So very small inclusionary statistics. And so from that, we were able to calculate the false positive rate overall, which is 1 in 20,000, or 0.005%. And then for match statistics greater than 100, that rate went down to 1 in 1 million, because there were very few false positives seen greater than 100 and none seen greater than 10,000.
And how does that compare to humans?
So in this paper, there were actually, when the lab did their human analysis, they had some false positives that would have been reported in their reports. So with the 1 threshold method, that error rate was about 6%. With 2 thresholds, that modified CPI, that was about 2% for the false positive rate. And with TrueAllele, it was 1 in 1 million, or 0.0001% for those match statistics greater than 100.
Reproducibility is the last prong of the 3 that we were discussing. And so what about reproducibility?
So with TrueAllele, because it uses a statistical sampling method, you're not going to get the same exact number every time, because it's going to propose and assess maybe possibly different combinations of those colored boxes. And so, but you'd expect similar results if it arrives at those similar genotype probabilities, those blue bars. And so with TrueAllele, we were able, between computer runs, to assess, what's that variation, what's that difference between those 2 runs.
Sorry. And this is when we talk about the 2 runs and the data has to be concordant, right? What is concordant data? And if it's not concordant, what do you do?
So what concordance means is it's just, when you run it one time on that same data, what's your match statistic, which is along the bottom. And then along the left, we plotted what was the match statistic from that second run. So every point, has the likelihood rate or the log LR from one run compared to that second run. And you can see if they were exactly equal, there'd be a 45-degree line they'd all line up on. Well, these roughly follow that, but there's a little bit of variation between them. And so we measured that variation, and it was less than a factor of 10. In this study, it was about a factor of just 2 different between the 2 different runs. And, when they're reproducible, you'd expect them to be similar every time. And if it wasn't reproducible, you see a number maybe way up in that top left corner.
This is yet another validation study.
Yes, so this was published in the Journal of Forensic Sciences in 2011, validating TrueAllele DNA mixture interpretation. And this study was mainly focused on comparing TrueAllele with human review. So it looked at 8 different case samples and then compare the match statistics on the left between 2 TrueAllele runs, so was TrueAllele reproducible, and then compared it with that human review, that threshold method of CPI. And TrueAllele got about 1 million times more information than human review. And this paper also has a lot of the published mathematics and equations and behind the TrueAllele technology.
And that was in 2011?
Yes.
Slide 20, like 2013 validation?
Yes. So this was published in the Journal of Forensic Sciences in 2013, New York State TrueAllele casework validation study. And in the study, we looked at about 80 different evidence samples, and then ran TrueAllele on them, calculated those TrueAllele results, which is that blue cloud picture, and then compared with the human review, which is those different colored bars. There were 3 different methods used with that match statistic along the left. And and what we saw is in about 70% of the time, human review didn't get an answer where TrueAllele did. And that just kind of expanded on that first paper we talked about from 2011.
And 2015?
Yes, so the next study was published in the Journal of Forensic Sciences in 2015, titled TrueAllele Genotype Identification on DNA Mixtures Containing Up to 5 Unknown Contributors. And again, this study also looked at sensitivity, specificity, and reproducibility. But we also looked at how does TrueAllele behave when you have, different contributor numbers, different amounts of DNA. So in this study, there were 2, 3, 4, and 5 contributor mixtures of high template, meaning a lot of starting DNA, and low template, meaning less starting DNA. And so we plotted again that amount of DNA from a contributor on our horizontal axis versus that match statistic, the log LR. And for each group, contributor number and low template, contributor number, high template, and then drew the line saying, okay, well, do they follow that trend where you have less DNA, lower statistics, more DNA, higher statistics? And when we compared those lines together, they weren't statistically different, meaning TrueAllele behaves the same regardless of if there's a lot of DNA or a little bit of DNA, or it's independent of the contributor number as well.
And what is the max of contributor numbers that is used for TrueAllele deconvolution?
TrueAllele has been validated out to 10 unknown contributors.
This slide 22.
So also from that 2015 Journal of Forensic Sciences study, we also looked at low template DNA and examined the sensitivity. So 2, 3, 4, 5 contributors. You can see with 2 contributors, you generally get more information, higher numbers, and then that trend goes, you can maybe get less information with 5 contributors, but you can still get information. And we were also able from this to measure false exclusion rates as well, or false negative rates.
And the specificity 23.
Similar to what we saw before, you're not seeing a lot past 0 on these plots, and it was measured for 2, 3, 4, and 5 contributors for those low template samples.
And what is the definition of a low template sample?
In the study, it was just 200 picograms, and it's generally anything 200 picograms or below.
24.
And then we also measured the reproducibility, again, showing that for 2, 3, 4, or 5 contributors, the results, including exclusionary results, are reproducible as well.
What do you mean by reproducible?
That each time you run TrueAllele on that same data, you're getting a similar number each time.
And how does that relate to validation and reliability and accuracy of the program?
It's just showing that, we're not just running it once and saying this is the answer. We're showing that TrueAllele's, looking at that same data and basically generating a similar result every time.
And finally, 2019.
Yes. So this paper was first appeared in the Journal of Forensic Sciences in 2019 and was officially published in 2020, titled Validating TrueAllele Interpretation of DNA Mixtures Containing Up to 10 Unknown Contributors. And this study showed many different things. Again, showed the correlation between amount of DNA from a contributor to, the match statistic. And then we also looked at some other aspects of independent analysis. So does who's running the software and where they're running it, does it matter? And so cybergenetics ran the same data in Pittsburgh, And then this was done with the Cleveland local laboratory. They ran it in their lab in Cleveland. And so the table on the left just shows we got similar results. Didn't matter who ran it or what computer they ran it on. And that was a less than factor of 10 difference between the match statistics. And then we also looked at, peeling, or when you can subtract out a person's genetic type and how that affected the data.
And I said finally, but I didn't mean it. The last one, finally, 26.
So slide 26 just shows that so we have a more updated way of calculating true allele error rates published in Helion in 2018. So efficient construction of match strength distributions for uncertain multilocus genotypes. And all it does is how to calculate those error rates by calculating virtually every possible person that could exist, comparing it with the data, and then saying what are those, specificity and sensitivity distributions. And these results were confirmed by comparing with that sampling method, or those 10,000 random people.
And I'm going to skip 27 because that's pretty much in my brief that I've already covered with the court, which I filed in September. So 28. Could you give us a summary of true allele today? Like, where is true allele today? First of all, is true allele new?
No.
Okay. Now give us a summary.
So true allele, the math and everything has been around for 30 years now at this point. The computer system was developed about 25 years ago. There's currently 10 laboratories using it, examine that data and produce those reports. It's been tested in over 40 studies, many different talks have been given about it. And then there's, the 42, times in the United States where true allele was admitted after challenge. And those are both in 15 states and federal courts. Cybergenetics alone has done 145 trials in, it's about 20 or to 25 of the states. And that doesn't count all, the user labs or the number of times that here in Georgia, in Ohio, in California, and the other labs that are using true allele, how many times they've gone to court on it. And just from, cybergenetics we've done now, it's over 1,300 cases in 46 different states for both prosecution, defense, innocence, and police groups.
And has cybergenetics or true allele also been used abroad, internationally?
Yes, it has.
And you told us about South Africa. What other countries?
It's been used in courts in the United Kingdom, both in Oxford Court and Northern Ireland, in Australia courts, in Israel courts.
And finally, your last slide.
This is just a summary from that 2014 validation study that true allele is, reliable, it's objective, sensitive, specific, reproducible, and accurate, and more effective than human review.
And if a person does true allele, since computer program, have a source code?
Yes.
And will cybergenetics permit someone to examine the source code?
Yes.
Tell us about the process.
So what source code is it's just human readable language given to any computer program, any technology that gives instructions for that software. And so that is then turned into the executable program or application on your phone, or even your phone at this point. And at Cybergenetics, we now have a policy where we will allow opposition experts or any kind of other expert to contact us to come in, sign non-disclosure agreements, and then review that true allele source code. I believe it's currently at our office in Pittsburgh. That's been the policy, and it's been on our website since, I believe, last year sometime, and it's also included in our disclosure materials.
And before I get to the disclosure materials, or maybe I should just do the disclosure materials now, because I want to ask you about something on disclosure materials. And I hand you what's been, may I first witness?
Yes.
What's been marked as State's Exhibit 35. For the record, did you look at State's Exhibit 35?
I did, yes.
And what's on State's 35?
It's the entirety of the true allele disclosure materials that were put together by myself and others at Cybergenetics, and then the GBI downloads to disclose in their cases.
And what types of material does the disclosure material contain?
So there are 4 different folders. The first is reliability, which has background readings, validation studies, admissibility rulings, and anything you would need for an admissibility challenge. Then validation materials and data, tutorials on how to use the software, and then a folder that contains a read-only version of the software where anybody could review the results. And then there's also an invitation for others to come and test the system on their own. We'd set them up their own little true allele server, and they can test whatever they want, and also that source code information.
And the state would move to admit State's 35 for the purposes of this hearing only.
We heard no objection, Judge. 35 submitted.
And if a person wanted to run a true allele on their own for themselves, would you permit them to do that?
Yes, if they reach out to Cybergenetics, we would set them up their own, true allele server on the cloud, give them the license to access the software, and then permit them to run whatever they wanted. Data in this case, other validation data.
Is a true allele reliable and reproducible?
Yes.
And is it widely and generally accepted in your scientific community?
Yes, it is.
And is it subject to standards and controls and protocols and procedures?
Yes. So there are certain standards and guidelines issued by some of the government agencies that deal with DNA methods, and they're for validating systems like Trulio. Trulio complies with that, and that information is included in the disclosure materials as well.
That's all I have. Thank you. I'll pass the witness.
Kirby?
Judge, I think that this relates to the motion to continue. I cannot confront this witness in a meaningful way without an ability to understand what she said. And if I heard it correctly, one of these math theories was used on the Enigma project. And I don't know if that was to create it or to break it, but either way, my understanding of that was that it was pretty complicated. And so I don't have any questions for this witness.
Okay. Can she be excused?
Yes, sir.
Thank you.
Oh, thank you. Judge, proceed.
Yes.
Say cause action, Hinkle.
Say the last name again.
Hinkle.
Hinkle.
And Judge, I think we do have a stipulation with this witness that might make the process go a little faster.
All right.
Raise your right hand, please, ma'am. Sorry, you stand. Sorry. Do you swear affirm the testimony you will give today in the matter of the state of Georgia versus Jose Ibarra will be the truth, the whole truth, and nothing but the truth, so yeah.
I do.
Where do you work?
I work at the Georgia Bureau of Investigation in the forensic biology section at the headquarters in Decatur, Georgia.
How long have you worked there?
Approximately 18 and a half years.
What do you do?
I am a forensic biologist trained in serology and DNA testing.
Tell the court a little bit about your education and your training, which qualifies you for your job.
I have a Bachelor's of Science in Biology from East Carolina University and a Master's of Science in Forensic Science from Marshall University. I also have extensive in-house training at the Georgia Bureau of Investigation and the National Forensic Science Technology Center in Largo, Florida. I also participate in continuing education, and I am trained in a software program for complex mixtures called TrueAllele.
Are you classified as a master scientist at the GBI?
Yes, I am.
And how did you get that classification?
I received that classification by staying around for 18 years approximately.
In your 18 years at the GBI, have you had the opportunity to examine items of evidence for blood, semen, and saliva?
Yes, I have.
Have you had the opportunity to process items of evidence for DNA?
Yes, I have.
And have you had the opportunity to run the TrueAllele program?
Yes, I have.
Okay. I'm going to ask you for each of those things, approximately how many times have you run the TrueAllele program? Let's go backwards.
Run the TrueAllele in the mid-hundreds, 400, 500.
And testify, test items of evidence for DNA?
Testified for DNA?
No, test items.
Test items,
sorry.
I'd be in the tens of thousands.
And test items for the presence of biological fluids.
I do that less often, so it's hard to say, but at the beginning of my career, I did quite a bit, so in the hundreds.
Could you please tell the court a little bit about your specific training on TrueAllele? When did you first get trained on TrueAllele, and tell us how long that process took and what your training entailed?
The TrueAllele training began in 2017. Since we are implementing TrueAllele at GBI, the training kind of ran concurrently to also writing the policies and procedures, so we assisted in that. As part of the training, we did quite a few readings on probabilistic genotyping and TrueAllele software. We had a visit and presentation from Dr. Mark Perlin, who is the head of the cybergenetics, which developed the TrueAllele. We also had practice on tests on mixtures were provided to make sure we obtained a correct answer.
And do you receive ongoing training for TrueAllele?
Yes, I do.
And in general, how to interpret DNA samples?
Yes.
Okay. Are you a member of any professional societies?
Yes, the American Association of Forensic Scientists and the Southern Association of Forensic Scientists.
Are you personally certified?
I am certified by the American Board of Criminalistics in the area of molecular biology.
Have you testified before as an expert in a court of law in the fields of forensic biology, forensic DNA analysis, and TrueAllele?
Yes, I have.
Okay. And in each of those, I'm going to kick out forensic biology. But let's just talk about DNA, forensic DNA? How many times have you been qualified as an expert in court in the field of forensic DNA?
All over, I've testified and been an expert approximately 300 times.
And what about true allele? How many times have you testified as an expert in true allele?
Approximately 60 of those were with true allele.
At this time, Your Honor, the state would tender Ms. Hinkle as an expert in the fields of forensic biology, forensic DNA, and true allele.
Any objection?
No objection to the admission as an expert.
Are you allowed to testify as an expert in forensic biology, forensic DNA, and true allele?
May I approach the witness, Your Honor?
Yes.
I'm going to hand you what's been marked as State's Exhibits 36 through 45, and since there has been a stipulation about these, this will go a little faster. I'm going to just show you State's 36. Is that your CV?
Yes, it is.
Okay. And 37 through 45, if you could just quickly look at those and tell me, are those all the crime lab reports that you created in this particular case that we're going to talk about?
Mr. Kirby standing for some
I
reason.
just wanted to speak very briefly. Sure. Sure.
See false positives, and we only reported above that match number.
Okay, so does that mean there's a threshold at the GBI in which you will not call a case if it's within the error rate?
There is a threshold where we will not call a match, yes.
A match, okay. Thank you for correcting me. Because you do create, or you do report matches on false or the potential of a false exclusion?
We have a range with our exclusions where there is a calculated average possibility of a false exclusion.
So of all the items of evidence that you tested in this particular case, did you follow your policies and procedures at the GBI in testing the evidence?
Yes, we did. I did.
And I want to say specifically to the true allele results, prior to going to true allele, did you test the items of evidence using traditional STR, DNA, typing, and analysis?
Yes.
And then how was it then that some items went to true allele, and don't tell me the specific items, but some items went to true allele and some did not? How do you make that decision as a scientist?
That decision is based on whether we can separate a mixture into individual contributor DNA profiles and then compare that to reference samples and match using the traditional DNA testing. We have methods where we can attempt to do that based on the percent contribution of DNA from two individuals. We can separate out contributors. We can also make an assumption that someone is present on an intimate item where we would expect their profile to be present. If we can use those methods, including another method or up to 3-person mixture, we can pull out a major contributor who's more than 75% of the mixture. So if we can use those methods, then we do not need to use true allele.
Do the policies and procedures then tell you if you can't use those methods that you then go to true allele?
Yes.
Did you receive known DNA samples or reference samples in this case of Laken Riley?
Yes.
Jose Antonio Ibarra?
Yes.
Diego Ibarra?
Yes.
And Argenis Ibarra?
Yes.
Okay, and did you process those items yourself?
Yes, I did.
Okay. And did you use did you follow your lab's policies, procedures, and protocols in processing those items as well?
Yeah, yes, I did.
Are you familiar with all of the policies and procedures that the GBI has on the True Allele software program?
Yes, I am.
And are you specifically trained in those and trained in them if they change over time or update over time?
Yes.
And have you all updated your True Allele procedures and policies over the years?
Over the years, because we started out from scratch, we have updated especially the reporting statements as well as what we need to include in our notes.
And every time that you all get a new testing kit like Global Filer or Identifiler, do you also have to then revalidate True Allele at your lab? For the new kits?
Well, we only use it on 2 kits, which are Identifiler and Global Filer, and those we have used since the beginning, and we have a validation for each. But there hasn't really been any changes in those kits, but if there is any changes to the True Allele software program, which also has a server connected to it, then that must have a performance check before it's used for casework.
And the performance check is done by the GBI?
Yes.
The items of evidence that you process in this case that are the results contained in your reports that we have already admitted, were those methods that you use generally or widely accepted in your scientific community?
Yes.
Were those methods published in relevant scientific journals?
Those methods have been, yes.
And are they reproducible and reliable, the methods?
Yes.
And in compliance with the GBI's policies and procedures, after you conducted your testing in this case, were your results peer-reviewed?
Yes, they were peer-reviewed by a scientist who is also trained in the methods.
And that is all I have, Your Honor. I'll pass the witness.
Judge, again, we're back to the expert issue, and especially as it relates to Ms. Hinkle. My understanding is that Ms. Hinkle would be the application of the underlying science to this particular case, so prompt 4 of 702. Without an expert to evaluate whether that was done correctly in terms of the data that we've been given that is not even in narrative form, I need an expert. And so until I have an expert, I will either reserve cross or I don't have any questions for Ms. Hinkle.
Anything else with this witness?
No, sir. May she be excused.
Excuse me. Thank you. Any other evidence?
Not on the Daubert for True Allele, no, sir. No evidence.
And I'm going to offer Mr. Kirby, but I don't expect it.
No.
Do you want a summation on this issue?
No, sir. It's in my brief, and again, I would encourage the court if you could take judicial notice of it, even without the need of a hearing, for Daubert purposes.
Okay. And I'll offer if there's anything else you want to say. Here's my plan or my thought on your issue related to the continuance in order to get an expert. I'm going to ask you if you can answer this question and what you said earlier and what I saw in your motion. As of right now, you have not identified an expert. Is that correct?
We have identified a potential expert, yes, Your Honor.
Which leads to the reason you're asking for the continuance.
Yes, we contacted an expert. They informed us that that's what they would need, and I would be hopeful that that is the number. In talking to other people, that seems like, I don't know. I'm hopeful. We've been trying since we got this information. So I just want the court to know that, and I want everyone, the state to know that this is not about purposes of delay. We don't want necessarily this to drag on any longer than it has, but we have a duty to our client.
But in reading your motion, you're asking to not only continue this hearing and leave that opportunity open, but you're also asking to continue the trial.
We recognize that the effect would be to continue the trial. And again, I've explained why that is, and we feel like we have to do that.
Well, let me give you some direction on that. It is not my intention at this stage, or based on what I've heard so far, to continue the trial for that purpose. However, I will leave open the opportunity if you want to bring someone in as an expert and if we need to have a hearing on that, not for continuance purposes, but perhaps to do some examination or put on your own evidence. I'll leave that opportunity open depending on what it is. I understand what you said, that you don't think you can accomplish that, but that's where we are today.
Okay, so just to try to get a clarification as to the court's ruling, there is not a denial to the continuance for this for purposes of today?
I'm leaving this open for you.
Okay.
But I'm not bringing back anyone else for that. It would be around the trial as a practical matter if you want to reopen some of that outside the presence of the jury.
Okay, thank you,
Does
Judge.
that make sense?
I think
I'm not trying to be
no.
obtuse about this.
Well, Judge, and I think that from a practical standpoint, it doesn't matter. It's just, we've explained our position in terms of confrontation, Sixth Amendment, corresponding sections of the Georgia code that we're asking, that we're objecting to this and asking for that continuation.
And I'll be putting this in a written order, but I just think as much as I can tell you today, because we're a couple of weeks off, you need to know. And
Yes.
that's why I'm trying to do that.
I appreciate that, Judge. Sure.
All right, where does that leave us then?
Argument on fingerprints, Your Honor.
Okay.
That's, I believe the defense decided not to call their experts. The evidence is closed. The state have nothing to rebut, so the evidence is closed.
You have that, Mr. Donovan?
Yes, sir. Just briefly, so we under 702, we asked the court for permission to leave the evidence open to possibly present someone. We're electing not to at this time, but the case law tells us that the burden would be on the proponent of the state of the proposed expert testimony. I'm citing their National EMS versus Smith, 368 Georgia Appeals, page 18. And this would include the burden to present evidence of reliability, not just evidence of the witness's qualifications. And another citation from a recent case is Humphrey versus Emory Clinic, 369 Georgia Appeals, page 131. And so in 702, I think it's B, has 4 prongs to it. It's not alternatives, but the court must be satisfied that all of them have been met. And we don't have the issue with the first 2. That is the experts training, or that the testimony is based upon sufficient facts or data. But really the second, the prongs 3 and 4, 3 being the testimony being the product of reliable principles and methods. And we would point out that, the witness acknowledged that, Detective Stewart that is, acknowledged the federal study pointing out a concerning error rate of false positives in fingerprint comparisons. And he acknowledged that was 2016 in this federal study that they refer to as the PCAST study, and that's acronym PCAST. And that study called for additional peer-reviewed scientific studies of fingerprint comparison for this to really be forensically sound, scientifically sound. And the state could not cite any, the witness could not cite any peer-reviewed studies that have addressed the problem that was pointed out in 2016. What he did testify to, and the state introduced these into evidence, was that in 2017, a body, it's a national body, OSAC issued guidelines setting out the ACE-V, another acronym, ACE-V method, and the witness said he followed that. That this is a widespread method and that it has been accepted. But also, again, there were no scientific studies to prove the reliability of this method, and specifically no testimony as to a known error rate, which obviously that's one of the things that the case law talks about in looking at for prong number 3. And in fact, the state made a point to bring that up in this last with the DNA witness. And then the 4th prong, the court has to be satisfied that the expert reliably applied the principles and methods to the facts of the case. I think this is a little bit bigger of an issue here. The report that the state introduced at the first part of this hearing of Detective Stewart's analysis is basically, well, the analysis portion of this report basically has 2 very conclusory sentences, and that report is in evidence. There's no detail, no documentation in tandem with the analysis from which another scientist or examiner, I guess, could determine whether the method that this witness used is capable of being reproduced, capable of producing reliable results. Yes, it was done a second time. There was a second analyst who reviewed the fingerprints and came to the same conclusion, but really without any documentation in tandem with the first examiner's analysis. There was nothing for her to follow. She was basically doing it anew. There was documentation presented in court to accompany his testimony, but that was not created at the time that he came to his opinion, that he formed his opinion. That was prepared simply for court, as a demonstrative aid.
Are you talking about the peer review?
No, I'm talking about the charts that he brought in with blow-up of the latent lift and with the known print. We had color markings on them. Those documents. But other than that, he didn't have any objective documentation of what he did initially to form his opinion, so that another examiner could review that. As far as the court's assessment of this 4th prong, 702, there's also the lack of an APHIS confirmation. The known print was included in the APHIS system, yet APHIS did not find a match, or even close enough, within 20 candidates, within a close example to the unknown latent lift. So, I understand the state's position is that this is a long-standing forensic method of fingerprint analysis that's gone on for years and years, and it's been introduced in courts all the time, and that it would be shocking for this court to exclude it, but there's not a Georgia court that I can find after 702 that goes into any detail about the admissibility under 702, since this has only been applied to criminal cases since 2022. So I'm sure to the state that this is a stretch, that we are asking the court to exclude the witness's opinion. What I am asking the court to do, if the court finds that the witness is allowed to give this expert opinion, we are asking the court to order that opinion be tailored. And in that regard, I have a case to cite, Hart, H-A-R-T, versus, Phone, P-H-U-N-G, 364, Georgia Appeals, page 399, that's in 2022. And that's a civil case with a car accident where there were, experts trying to talk about lighting conditions. And the court in that case held that this one particular expert could not go as far as to describe what the lighting conditions would have been in the situation. But he was allowed to testify to things that could help the jury. That these lights on this vehicle would have provided this illumination. The light on the street would have been, provided this illumination. The distance that the pedestrian was from the vehicle was this. He could have given opinions that would not have otherwise been, known to a layperson, such as the illumination that the vehicle would have provided. But he couldn't go so far as to give a more specific opinion as to what the driver could have seen. And so, in this case, and I understand that it's somewhat different, but what they did in that case, the Court of Appeals on the review said, look, we're not finding error with the trial court's admission of that expert to give an expert opinion, but that it should have been more tailored and that it went too far. And so I think that this court will be authorized to do that. And what we think that based on Detective Stewart's testimony, so again, I'm referring to the document that the state introduced as far as his written report, essentially 3-page report, although the third page there's no content on it. But the second page of that report, where he comes to his conclusion, he says that the latent and the thumbprint of Antonio Ibarra have a great deal of corresponding ridge detail. But I'm not going to read the whole thing, but there's 2 sentences there that his policy authorizes him to make as far as the similarities between these 2 fingerprints. But the last sentence, when he says the left thumb of Jose Ibarra is the source of the latent on the cell phone, we would object to that, to him being allowed to say that. And that is in keeping with his own policy. He testified, and it's in evidence, the police department's policy, also the OSAC guidelines, which are also in evidence. Neither of those authorizes an examiner to go that far in his opinion, and the science just doesn't authorize a claimant that bold to make a statement that this person is the source of this latent print. They can't even see the entirety of the latent print, as we saw in the blow-up. So we would ask that if the court does allow the witness to testify as to an expert opinion, we're asking it to be limited to those first 2 sentences in his conclusion, and to prohibit the witness from testifying to that last, more broad and unsupported statement. If that makes sense.
I understand. Thank you. Charles.
Again, Your Honor, the state had filed a response to their Daubert request urging the court to take judicial notice of the reliability of fingerprint evidence. And counsel said there is no Georgia case on point, but the last time I checked, the 11th Circuit Court of Appeals is in Georgia. And the 11th Circuit Court of Appeals held in 2023 that fingerprint evidence is so widely accepted. And I cited to the court an opinion from 1911 where fingerprint evidence was discussed, that fingerprint evidence is so widely accepted in the federal circuits, which is what our Daubert statute models under 702, 24-7702. The Georgia General Assembly tells this court we have to look to the federal circuits. And in looking to the federal circuits and looking at the 11th Circuit, in 2023 they have held it is so widely accepted that you don't even have to have a Daubert hearing on it. You don't. We asked you to take judicial notice of it, but we had a hearing anyway, which is great. We have a great record. And on this record, there is no basis to grant them the relief that they are seeking. And it's interesting that they are now challenging the reliability of fingerprints in general, because when we had our discussion about why we're having a Daubert fingerprint analysis, it was more they were attacking the expert and the way that he did it and not fingerprints in general. But even if they're attacking now fingerprints in general, they had the opportunity to ask the expert if fingerprint evidence is unreliable. I'm assuming he wouldn't agree with them. And he did talk about generally how reliable fingerprint evidence is done. And he talked about the ACE-V method. And the reason why that is so important is because the V is for verification, and his work was verified. But there's also, since 2022, since Daubert was enacted in criminal cases, I do have 2 court orders from other superior court judges in this state who, like Your Honor, have had Daubert hearings and fingerprints, who have talked about specifically the ACE-V method. And you can find the ACE-V method in all the cases that I cited to the court in my brief about it being inherently reliable. And so if I could, one is out of Fulton County and the other one is out of Augusta. There are 2, just obviously it's persuasive authority, but I just thought I would share these 2 court orders with the court on fingerprints and ACE-V. May I approach? Sure. So we request that you deny their Daubert on fingerprints, and the request to limit the expert's opinion to something that is really no opinion at all It's just not logical and supported in fact. He's an expert in fingerprints, not lighting. I could see a civil case that I haven't even read because I didn't know he's going to cite it, where you don't need an expert to talk about the lighting. That's really kind of something the jury can figure out. But he's talking about fingerprints and matching a fingerprint to a known item of evidence. And so we request that you allow him to testify to his full opinion, which was outlined in his report and which was explained to Your Honor a few weeks ago.
Does that cover the subjects that we were?
The only other one was the motion for particularized witness list.
I mean, I guess you're just, I haven't seen the list, so I don't know. Does the state have a position on?
Yeah, I have
what they may do
told them,
about
but just
that?
haven't done it yet because we've been so busy preparing for motions. I will limit and tell them, I will give them a range of civilians that I'm going to call. I have told them I am hamstrung because I'm not sure what they're going to do, and I'm always able to call anyone on my witness list. That's why I put them on my witness list. But so that the trial will move efficiently and they can be prepared, I will give them a narrowed list, but I'm subject to calling anyone on the list, which is why I list them. And I don't want to box myself in because I don't know what they're going to do. So obviously they could do something that's going to require me to call someone who's on the general witness list but wasn't on the narrow witness list. So my way of saying I want to be agreeable, I want to help, and I want to narrow it for them, but I can't be bound by what I tell them because I have a burden of proof here. And if they do something that's going to require me to call someone that I've already listed, I reserve my right to do that.
And Judge, I think we put it in our motion. I'm happy to put it on the record here again. We don't object to that position. We're not asking for the state to commit themselves to only calling these witnesses. We're not asking the state to limit their rebuttal possibilities. We're just in good faith trying to prepare this trial. The data is voluminous, and so we would just have some notice of who the state actually has under subpoena that would just allow us to be ready on November 15th.
Okay, sounds like that's done.
Yeah, and it would be helpful if the state had gotten any witness list from the defense, and I know we're not 10 days out yet, but once I get a witness list from them, then I can better limit and tell them who I'm going to call.
That sounds reasonable, doesn't it, Ms. Beth?
If we have witnesses to call, we're happy to alert the state, but at this point, I don't know, we don't have any witnesses beyond the state's witnesses.
All right, I'll leave that to you all. A couple things. One is, I just to kind of give you all an idea of how I want to try to proceed on the 13th. I've talked with the clerk's office. We're going to go ahead and bring in all the jurors Wednesday. Y'all have done a good job in coming up with a juror questionnaire. I mean, I think it's 53 questions, and I think that will tell you all a lot, but of course it's going to take some time. They'll get checked in. They're all going to be given the questionnaire. Then they're going to be loaded. These are just kind of housekeeping things, but I think it's helpful to you. They will put them on iPads, 2 or 3 per side, load them on. If you all want to take your iPad and download printed copies or print out copies, you're going to be able to do that. As soon as we're able to identify, get them in panels and do the first 12, those are the questionnaires I'm looking for first, even though they'll all be doing them. We'll go ahead and start the void hour for them. We're going to do everything in the courtroom across the hall that are known as Judge Stevens' courtroom, from jury to trial. I think it just makes sense now that I've thought about it to do everything there. I also will tell you now it is my intent to have jurors referred to by their summons number, and the questionnaires will of course not be available to anyone either. Also, I will, since you all have done such a good job on the questionnaire, I am not looking to spend time in void hour asking those questions. I understand there will be follow-up, but I'm also not looking for what I call rapport establishing questions. They're going to get to know you pretty well during the process of this. Certainly, I'm going to let you introduce yourselves and everybody, but we're going to be able to do that early on. I'm just looking to not spend more time than we need to with them. It's going to be cumbersome enough as it is. The last thought I have is y'all got a notice about plea day on that calendar for the 12th. Unless you all tell me differently, I don't know of a reason to call you all together for the 12th. If that changes, let me know. But I mean, we can make room. But I'm also not saying that to invite a time to hear other motions and all of that necessarily, because I'll have other things to do. But I just let you all know that we need to be here for that.
So we are officially excused from the 12th?
That's correct.
Thank you.
I have one logistic question. We had talked about the possibility of individual void hour and following up on some of the questionnaire questions, and the reason I ask that is because obviously some of the questions will deal with what actually do you know about the case, and I don't want to ask that in front of other jurors.
You want to be heard on that?
What is the court's general policy on that?
Okay. I do sequester voir dire from time to time, especially when there is allegations of sex acts. Sometimes people are not as forthcoming with their issues related to that. So that alone. But I can also see a reason to do it in this case as well, just as something as Beck just mentioned. So the way I usually work that is, of course, we end up with 12 jurors over there. We put them in the jury room and bring them out one at a time. And if there is some follow-up with each one, then we address that then. Then, as a practical matter, I usually have them step outside, and then I entertain any motions related to that particular juror. So we have sort of a running total of who we qualified. I hold the other panels. I try to stage it so that they come in and they're not waiting, but they would have to be waiting probably out here in this atrium. We may have another place for them to wait and gather as well. That's what I'll be looking for, but that's usually what's done.
When you handle sequester, why do you handle just that sensitive topic, or do you go ahead and complete all the questions for it?
I usually do everything for that juror. I think but in this case, with y'all got all of those questions ahead of time, I just do sequester voir dire, anything that we think has to be dealt with on that particular juror, not just what I call sensitive questions.
Yes, Judge, and I would just offer that at least right now, our position is that we don't need to question the jury in groups of 12 if we're doing individual voir dire, because all of our general group questions would be in the questionnaire. So,
with the exception of, we did not put the statutory questions in, and so are you going to bring them all in to do the statutory at one time and let them know certain things like, this is not a death penalty case, and we're going to take your phones, and you're not going to be sequestered, all that kind of stuff they want to know?
They live here in this county.
Yes, all that stuff would be...
Those statutory questions I'm going to do as a group, I hope. May have to do it two sections, but I'll have to ask all of those.
And the one thing that I did not put in the questionnaire is an actual witness list like I made. So I need to plug that in. Do I email that to the court, or how do I plug that in? Or do you want me to plug it in and email it back out to everybody?
You can email it to my office, of course, copy all parties, but that'll be fine. I'm hesitating because with the stipulation about trying to have the list, I don't know how exhaustive a list we're talking about.
So what I could do is, what we've done in other cases, is when you do the statutory questions, either you could read the list at that time for the entire panel, just ask them to raise their numbers, if they have numbers, or I could read the list at the time, or they could read it, and we could just figure out how we could read the list at the time instead of writing it out. I've seen it done both ways. Sometimes we print it. Sometimes we just, when they're all together and you're doing your statutory questions, you usually hit the buzzer to the state and you just read out the witness list and say, raise your number if you know these names. And then we can just note it and then follow up on it when we follow up.
I think Your Honor's concern is I would request that rather than reading the 265.
I'm not doing that.
Okay.
It'll be a reduced list. It's not going to be 265
Okay.
pages.
Well, let's try that, because they're going to be overwhelmed a little bit by the questionnaire as it is, much less.
So try reading it, not putting it in.
Yes,
Yes,
and
sir.
it doesn't matter to me too much whether I do it or I tend to say it's your list, so Ms. Ross reads them out.
Your other judges are in your company, yes.
Okay. Anything else we need to talk about?
Two other additional matters briefly. I need to give the court a court order for State's Exhibit 31 from today, which was the thumb drive. So I will just submit that via email to all parties. That will give the court the opportunity to in-camera review it and then decide if you'll want to sign that order. And then we would like to just make a record to make sure that the translation is going well and there are no issues with translation. We don't see any, we don't hear any. I just want to make sure that the defendant is understanding the proceedings for the record.
What form would that be? I don't understand.
Well, I guess I'm looking for, and I think it's a reasonable request while we're here on the record, is there any problem with the translation? I assume the equipment is working and your client's getting the information. If there's a problem, I would like to know it.
Certainly we would bring that to the court's attention.
Okay.
Yeah, I'm not aware of any either. I just don't know what we're looking for there, an affidavit or a...
No, I don't think so.
Oh, yeah, I'm not aware of any, so.
Okay. Well, certainly that door's always open if there is.
Your Honor, now and then I ask him, are you understanding what I'm saying? Yes, so I just need to make sure that you understand what I'm saying.
Okay. Because we are also dealing with electronic, I guess there are batteries involved. I don't
I
know.
have them.
Okay, all right.
Everything.
If something starts happening, let us know. All right, thank you all. I will take, before we get some nervous about this, I will take 31 and hold it.
I'm going to sit here.
You also have a little extra chance.
I do. I'm really bad at things. It's here somewhere. Here.
31, I believe, was her number.
31 is definitely the number. I can say your name wasn't on my mask. Yes. Jane, can I have it? 35 is in.
I noticed that today. I did 5.
It's going to be soon, I expect. Turned off.